Yeah, no, it is up to you.
May I be permitted to mention not the matter which your lordship has reserved judgment?
Yes, yes.
Child custody issue.
Yes.
Little urgency is only this, not that now the exams will get over next week.
Please
And
wait
then-
for a day.
Very well, I understand. Much obliged, not sorry to normally I would not have mentioned it.
My lord, item number 105, my lord.
Yes.
My lord, next date before the court bill is 3rd of June.
105 for what?
My lord, 105 for upgradation or
No. For what the date is fixed?
my date is here for the further examination, my lord.
What is the impugned order?
Impugned order, my lord, dismissing my lord order 6 rule 17. This is the pre-amended suit.
105. Yes.
And my lord, kindly to mention a matter, my lord. My lord, this is for an expeditious disposal, my lord.
No urgency. Yes.
Subject to the leave of the court, my lord. The last
Please don't mention any matter which cannot wait
subject to the leave
after
of
the vacation.
Last
Please
occasion,
don't mention.
my lord, last occasion, my lord was pleased to direct me to mention today. In fact, my urgency is that my retirement benefit has been stopped by the
What is
authority.
the item number?
Now, item number it is running 1238.
1238 monthly list. Yes.
May I permit to,
It is running in that.
Yes.
may I permit to mention extension of interim order
When it is expiring,
this month.
extension of interim order, please hand over the slip.
May I have your lordship say, put in a matter to go out of the list, section 24 application. Item number 248.
248 of the supplementary or monthly? 248 for want of determination, for want of. Yes.
Your lordship, may I be permitted to mention for restoration a matter on that particular day due to heavy torrential rain.
All right, hand over the slip.
149 today's
In that event,
149 today's list, my lord, amendment. Written statement has been rejected. Next date has been fixed on 6. Written statement has been rejected.
Written statement rejected.
Not accepted. Sorry, not accepted, my lord. There is a delay of 2 days. But I will show, my lord, there is no delay. Now,
Length of the delay is not material, Mr. One
149.
supplementary list. 149 টা mark করে রাখুন. Yes. Inclusion, please mention after the vacation. Please mention after the vacation. Please, Sujana, please mention after the vacation. All right.
Lordship,
Inclusions, please hand over the slip. Inclusions, please hand over the slip.
On the 5th June, the day
Lordship, may I?
hearing of the application for police helper.
Please wait.
Lordship, may I?
Inclusions, please hand over the slip.
Lordship, may I kindly?
Item number 1437 and 1438 of the monthly list.
1437
and 1438 of the monthly list.
Yes.
The opposite party number 1 is a senior citizen. The eviction should, petitioner has obtained stay in the last year, my lord.
All right.
Stay is still continuing, my lord.
Yes, yes.
Any date after
Please mention after the vacation. Yes.
Lordship, for
Lordship, may I?
my lord, may I permit
Yes, yes. Please mention.
contempt upgradation, my
For
lord,
inclusion. For inclusion.
upgradation.
Upgradation not possible. Yes.
Lordship, may I please kindly take your leave to present the matter virtually? I am the petitioner in person.
Application for hearing of the police helper. My lord, for
What do you want? Expeditious hearing?
not my lord, for upgradation, my lord.
Upgradation, no urgency. Yes.
Contempt application
Yes, please wait. Yes.
regarding overdue allowance, lord.
124. What is the urgency?
Lordship, am I audible?
Is from suppressing the fact that similar cause of action writ is pending.
Electricity installed.
Yes,
So you want disconnection?
my lord.
Not now. Yes.
With regards
Lordship, please, may I?
33 of monthly list.
Yes.
My lord, next date is 3rd June, my lord.
For what?
For hearing of the application, my lord, order 7, rule 11. My application.
Nothing will let it be hard.
My lord,
Hearing, let it be hard.
no. I have challenged the order 6, rule 17. That was dismissed. And they are now proceeding with the my rejection of plaintiff application. My lord, the trial court passed order, my lord, number 533.
I did have 533 monthly is not করে রাখুন.
Lordship, may I permit to mention, lordship?
I mean, yes, কাগজটা।
The petitioner is a DP holder and the opposite party.
What do you want? What is the grave urgency? You cannot wait till after the vacation.
They are not paying a single farthing, my lord, kindly enjoying.
That is not the urgency. Yes,
Leave to file and
Lordship, may I-
please, because Lordship will have difficulty taking up this matter because of the, my lord, constitution of the arbitral tribunal. Order impugned is passed by, my lord, learned commercial court.
file it.
My lord, may it appear to move it because of the urgency. My lord, may it appear as in the supplementary list today, my lord. I only seek release because Lordship won't be able to.
Lordship, for overdue allowances, Lordship, that
2 p.m.
Under
2 p.m.
Act, and which has been repealed. But as a result of this, my entire retirement benefit has stopped by the.
You have mentioned, sir. I've said, please. I've noted the number.
One more prayer. Your Lordship doesn't take in that event. Your Lordship allow me to take the chance in the vacation bench. Your Lordship allow.
You want that? Achha, ওটা release করে দিন।
My lord,
What is the item number? What is the item?
Sorry.
fix করলেন তো।
Fix.
Lordship, may I permit to mention for
If you want, I can release that. You can try your luck because the vacation bench.
contempt application regarding overdue allowance, Lordship, section
Contempt
50.
application,
Yes,
you want
Lordship, kindly
enlistment.
because yes, Lordship,
Hand over
order
the
was
slip. I've
passed-
said, hand over the slip for
Take this
institution.
matter, order was passed on 8th September, Lordship.
Please hand over the slip, madam.
Lord, extremely urgent matter, my lord. I'm the mother, custodial mother, my lord. I'm the custodial mother. The trial court has directed the hand over the child to the father for 7 days continuously during the summer vacation. From tomorrow, 17th, the order was passed. We applied for certified copy. But for the, I don't know, the server copy with the stamp has been given to us. And they allow me to file it and my lord, move it today, my lord. Otherwise, it will become
Tomorrow.
it will become infructuous. Tomorrow at 11 a.m. I have to hand over the child.
No, not today. Yes.
Lordship, may I be allowed to mention? This is a matter
Tomorrow.
number 450.
Lord, I need leave.
Tomorrow.
I need leave.
Lordship, tomorrow is the last day in the trial court for hearing, for final hearing. And
What is
today,
the impugned order?
Lordship, the order is that there is a res judicata that has been filed. So,
Judicata that has been filed, I could not follow.
uh,
What is the impugned order?
um,
Madam, please go through the brief then. Yes, Mr. Mukherjee. Yes, Mr. Mukherjee.
One matter has been wrongly filed before your lordship could, my lord, because my lord, against the order of the tribunal, my lord, I have to file WP LRT, my lord. Revision has been filed, my last. I want to withdraw. Can it be appear as supplementary list, my lord, at 2 p.m., my lord?
It is not appearing in the list.
No, my lord. Supplementary list,
Why?
because my date has been posted on Friday, but yesterday when brief has been given, I found, my lord, that no, my lord, last day limitation will come.
What did they say?
My lordship,
You are fine. There is a provision.
my lord, let it. I will withdraw, my lord, only, my lord, at 2 p.m., my lord.
You have said limitation cannot be
I
applied.
will withdraw, my lord, because I have.
Hand over the slip, it will appear. Yes.
My
Yes, Mr. Rai.
next date is the 13th June.
For what?
69 rejected, suit for
Order 26, Rule 9.
suit for on the ground of utility right, that too by encroachment. Then what how the injunction appeal will be hard because 26 Rule 9 is rejected. That is the only provision for the purpose of encroachment. Other than the court, how can the court prosecute the purpose of it?
Item number
100 and 100, 100 and 101.
in the supplementary list.
My lord,
Note করে রাখো। 100, 101.
my lord, expeditious application of execution proceeding. My lord, this matter is,
Emergency, yes.
my lord,
My lord, please,
pen-
madam, can you not wait till the after the vacation?
my lord, this is pending for the last 7 months, my lord.
Yes, so can you not wait for 15 days?
Yes, my lord, but kindly humble,
Please wait for 15 days.
this
If you have waited for 7 months,
my lord, this is my 5th mentioning, my lord. Kindly, it's a humble request, my lord.
madam, you cannot wait till after the vacation.
May I-
Then I have to update all the matters. None of the matters can be taken up. Please consider this. Expeditious hearing, there is no urgency.
Some execution is
Then I have to
pending
think of
since 2018.
deciding these applications in another way, following the Honorable Supreme Court's judgment.
may I be permitted to mention before your lordship for release, my lord. This is a section 24.
Please, section 24 CPC.
Yes, my lord.
CPC. What is the item number?
My lord, it was item number 1078 of monthly list of April, and in monthly list of May, it is not mentioned, my lord.
It is not appearing.
Listed.
Then it is out of list, madam. Please mention before the bench.
My lord.
Application, it will appear in the monthly list.
Next date, 11 June.
Maybe. When did it expire? 8th of this month. Yes, Mr. Bhattacharya.
Item number 1219 of the monthly combined list, my lord, I am facing an execution, my lord, I have to hand over possession.
144 is there, Mr. Bhattacharya. Hand over the possession.
No,
If you succeed, restoration will be there.
let me try my luck before any of
Restoration is there, provision is there.
days, without any of these 2 days, my lord.
1219.
1219.
Monthly list. Mark করে রাখুন।
My lord, I am giving this. Giving this.
Milad, the prayer Milad, I am seeking Milad to file Milad and move it tomorrow or today Milad anytime.
File it.
No,
where?
Milad, what is, no, but there is a direction of your lordship that Milad, before 48 hours Milad, nothing to be listed Milad, what I am being told. May it appear tomorrow Milad. Please make it right.
Yes.
My lord, item number 46, my lord, I will mentioning, my lord, it's because I obtained an interim order of injunction which was stayed in the miscellaneous appeal, my lord, without notice. Carrying on, my lord, construction unhindered.
Let me see how far I can proceed.
My lord,
Yes.
if you is not able to, lordship kindly considers my urgency. I am handing over this.
Yes, yes, I'm considering, I've marked that item,
My
item
lord.
number 46.
My
Yes.
My lord, I'm mentioning item number 706 of the last monthly list, my lord, I've mentioned it for the last 3 occasions, my lord.
What is the urgency?
It is not in the list, my lord. Let it be just included in the list, my lord.
706 is in the list.
No, my lord, it is not in this monthly list, my lord.
It is not in the monthly list.
Somehow it has went out, we mentioned, my lord, subsequently it did not appear.
What,
Item number 706, I
hand over the slip,
handed over the slip, I'll indicate.
monthly list add করে দেবেন। Yes.
I could not my explain my lord, what happened. I obtained an interim order. Now, but subsequently, my lord, KMC filed an application for vacating. That application was allowed. My notice for demolition has been given on Friday. I have posted the date tomorrow, my lord, in the motion list. But if the today matter be released, my lord, but tomorrow matter.
My lord.
Let it appear to be mentioned, my lord.
Why to mention? Let it appear on,
I will withdraw, my lord, only because I have to file the writ petition.
let it appear tomorrow.
Has to be mentioned. Otherwise, if the matter will appear, my lord, in the item number, whatever may be the item, but because I have to file tomorrow, my lord, before.
Let it appear, mention tomorrow, because it cannot be, if you have mentioned in the list, it will appear in that.
May I have your lordship's kind leave, my lord. Item number 323 of the supplementary list, my lord. The impugned order is an order of dismissal of my 710 application, my lord, for return of claim. My lord, the next date fixed is the 4th of June. There is a custody, my lord, application, my lord, which is pending. If you kindly takes it up, my lord, I want to come back either of the 2 days remaining, my lord. If you permit for on the 4th.
Nothing will happen.
The 4th.
Nothing will happen if it is considered. Let the suit proceed.
The child has been called again, my lord. That is
The different.
may I
Please,
come back for like 15
let the
minutes?
child appear, nothing will happen. Yes.
Lordship, item number 357 in the monthly list of May 2000.
357.
Yes, Lordship, this was mentioned for early.
It is
hearing.
the urgency.
Lordship, Order 7, Rule 11 has been filed and is pending. I was only praying any day after vacation, Your Lordship.
Expeditious hearing.
Expeditious.
Please mention after the vacation.
Lordship, I have mentioned 4 times.
Please
Your Lordship,
mention after the
my
vacation.
application will get any day after vacation, Your Lordship. Any day.
There is no
Lordship,
urgency in expeditious hearing matters.
Lordship, urgency is the Lordship. May I? To Lordship, the
Sir, can you not wait after the vacation?
because the Lordship, my application will get because there is already an injunction as against an Howrah property passed by City Civil Court, Your Lordship.
Yes.
Lordship, I have mentioned my Order 7, Rule 11 has been kept pending. Next hearing is fixed in September 2025.
All right, so you cannot wait. That is why I'm asking you. You cannot wait till after the vacation.
Already, any day after vacation, Your Lordship, I can.
That is why I've asked you to mention after the vacation. Please, only
I had
2 days
mentioned
left.
also, Your Lordship, my
Only 2 days left. That is why I'm asking you.
Lordship, I had mentioned earlier. Also,
Otherwise, I have to take all of you. Please
after
consider.
vacation, any.
My lord.
That is why I'm asking you to mention after the vacation.
I will mention again.
Yes.
My lord.
Well, my lord, the petitioners being tenants suffered a decree of eviction. They are not paying, my lord, any occupational charges, enjoying stay in the execution proceeding. My lord, the respondent number 2 is, my lord, 80 years old, my lord. We are being a landlord, we are suffering, my lord. Any day may be fixed after the vacation. So the stay.
Please mention after the vacation. Please mention
My
after those matters which can wait till after the vacation. Please mention after the vacation.
My lord, may I be permitted to mention, my lord?
Item number 284, wrongfully appending the motion. That is the extension of interim order, my lord.
Extension of interim order. Yes.
My lord.
Serial number 207, Lordship. Lordship, I am a recorded Borgadar. And Lordship, my Borgadarship has been challenged before the civil court. And Lordship, the next date is 22nd.
For what?
For Lordship, for hearing.
27th of what?
22nd of this month.
Nothing will happen. Yes.
Lordship, kindly take it, Lordship.
Yes. No urgency, yes.
My lord,
May I be permitted to mention, my lord, item number 291 of the supplementary list, my lord. No, I'm suffering. I'm the defendant in the suit below, my lord. I'm suffering a temporary injunction order against me, my lord, and I have obtained a sanction plan, and thereafter I'm making construction that has been suppressed before the landed court below, my lord. And my lord, have come up against.
Come after the vacation, yes.
My lord, may I
my
just.
lord,
Please
There are
come
raw
after the
materials,
vacation.
my lord.
Please come after the vacation, yes.
Lordship, there is a matter I have filed on yesterday after taking leave from the Honorable Chief Justice. Lordship, this is a Port Blair matter. The ground of urgency is that, Lordship, there is a peculiar.
Port Blair matter
Yes.
tomorrow. Tomorrow it will appear.
my lord, may I be permitted to mention a matter, my lord?
Yes.
My lord, I apologize for appearing online like this, my lord. Because of some unseen circumstances, I'm
Yes.
online, my lord. My lord, this
Yes.
matter is appearing as item number 1498, my lord. It
Yes.
relates to a matter of unauthorized construction. The other side has obtained a stay, my lord, from your lordship's court. We have filed a vacating application. My lord, if the vacating application could be listed after the vacation, my lord. That is our only prayer.
This file it will be listed, yes.
My lord, may I?
It has been filed, my lord. It has been filed. It has been filed.
Apply the number, it will be listed.
My
Yes.
lord, can my colleague please hand over the slip, my lord?
Yes, yes. Ask your colleague to hand over the.
My lord,
Mr. Dasgupta, please hand over. Grateful, my lord, grateful.
Yes.
My lord, I apologize. I'm appearing in person. I'm the petitioner in person. This is case number 3571, which appeared in the monthly list of 5th May. And my old advocate gave me an NOC, and my new advocate is not taking any steps. So I'm forced to request that if it may be kindly put in the to be mentioned list.
Please
Because
supply the number, it will appear in the two mentioned after the vacation.
My lord,
Yes.
my lord, may I be
My
permitted?
lord, it is urgent. It is regarding urgent interim custody during vacations of my son, my lord. During vacations, I want him to come to Delhi from Kolkata, my lord. I live in Delhi. I'm in Delhi. My only request is kindly.
The number it will appear to be mentioned tomorrow. Yes.
My lord, may I?
Restoration application.
3571, my lord.
I have filed a restoration application, my lord, which was dismissed.
Yes, please hand over the slip. It will appear. As
My
said,
lord.
institutions, please hand over the
My
slip.
lord, may I be permitted to be mentioned, my lord, item number 753. My lord, the agencies opposite parties file and petition suit and also file an application order 39 rule 1 and 2 with suppression of fact and learned trial court reject the application. Therefore, my lord, the opposite parties file an appeal against the trial court order and appellate court allow the application and grant the injunction order, my lord, without merit of the facts.
When the order was passed,
My lord, order was passed, my lord.
please mention after the vacation. Yes, Mr. Halda.
My lord.
The mother filed a suit for eviction of my lord tenant, my lord. In such a suit, my lord, during pendency of suit, mother transfer by way of deed of gift, transfer the suit property, my lord, in favor of the son. My lord, I took out an application for amendment, my lord, seeking just 2 lines amendment, my lord. That during pendency of the suit, mother transferred the suit property by way of deed of gift. The learned court below by order improved rejected the said application for my lord amendment solely on the ground, my lord, that I have, my lord.
What is the grave urgency, Mr. Halda? You
But
cannot wait.
tomorrow is the date
For what?
For leading, it is fixed for my lord evidence. My lord, I am not in a position to lead any evidence because my lord, unless and until these 2 lines are incorporated, my lord, I am not in a position.
When you have filed the revision application?
Much earlier, my lord. My lord, it was filed on 9th December 2024. On last occasion, I mentioned this, my lord, your lordship asked me, my lord, to wait for some time. Tomorrow is the date, my lord, for evidence, my lord, for last special chance, my lord. 191 of the combined list. 191 of combined list.
191 of please give the slip. Yes.
Item number 161 of today's list, my lord.
Yes.
The matter in which the learned state commission, without granting me opportunity of hearing, allowed the revision petition and set aside the order impugned. Now, this matter was taken by your lordship on 13th May, my lord, when the opposite party, without any caveat, appeared and prayed for a copy or supply of a copy. My lord granted. I have served the copy, my lord.
What is the next date fixed?
My lord, it is after the vacation only, my lord.
Please mention after the vacation.
My lord, item number 55, my lord. Item number 55.
Of today's list.
Today's list.
Yes, what
My
is
lord,
the urgency?
Urgency, my lord, on 22nd May, date fixed for further evidence, my lord.
What is the impugned order?
Impugn order, my lord, rejected the prayer for evidence in
number 55.
Article 55, my lord.
Mark করে রাখুন এটা, 55.
I'm getting it.
Well, this
Mention my lord, item number 1 of the monthly list, my lord. This matter was previously of the February, my lord. To file a supplementary application, the matter was directly to obtain a monthly. Or since then, appealing to the list, my lord.
Please mention after the vacation.
Prayer, my lord, that it may be.
You cannot wait till after the vacation.
But 12th June is the
I'm
date.
asking you, you cannot wait till after the vacation.
But I am asking for it to be listed on top after the vacation, my lord.
Please mention after the vacation. Please mention after the vacation. Let the monthly list be
My lord,
published.
this matter was appearing in the monthly list of April 2025, but subsequently it was not appearing in the monthly list of May. I had mentioned this matter earlier also.
Hand over the slip.
Difficulty is that, my lord, the file is lying in courtroom number 17.
That is why it
That is
could
why
not be
if
listed.
your lordship kindly directs the officer to list it in the next monthly list, that will suffice.
Yes.
Your lordship, I'm mentioning for inclusion application, your lordship.
My lord,
Yes.
Your lordship, may I be permitted to mention item number 1697 of the monthly list of May, your lordship? By an order dated February 17, 2025, your lordship had extended the interim order till the month of May, till the end of May, your lordship.
You want extension of interim order?
Yes, your lordship.
My lord,
Yes.
may I permitted to mention a matter regarding Monday it was taken up, my lord. My lord, there was a direction to get back the certified copy, my lord. But
Yes.
till today the server has not been published, my lord, that I am not
The
able
number.
to.
রেখে দিন তো এটা। Yes, yes, call the
My
list.
lord. My lord, I apologize. Please, sir, just 1 second. I'm not able to give a mentioning slip. So if I may be permitted to, if you may kindly,
Please, you have to give the mentioning slip. Please give the mentioning slip. Yes.
it's item number 1491, my lord. If I may be kindly requested to mention.
1491.
Yes, in the monthly list of 5th May, lordship.
All right.
Highly grateful.
All right. Yes. কেউ নেই তো এখন এখানে, না মেনশন করেছে এখানে 552 তে করে দিন তাহলে। আইটেমটা কল করুন একবার, দুটো আইটেম গুলো কল করে দিন।
monthly list করতে হবে, monthly list
আইটেমটা কল করে দিন।
What number? Monthly list. 139.
monthly list 139.
For want of determination, let the matter go out of the list. Next,
1056.
same order. হয়ে গেছে? Call the list.
list. Item number 3, daily list.
Yes.
But I appear for the petitioner in this matter. Your lordship may remember, my lord, on the last occasion we gave names of 5 English medium.
I'll humbly pray, my lord, Mr. Ujjwal is appearing on the opposite party, my lord. He is on leg at 225, my lord. Seeking for a very short passover, my lord. Very, very short passover, my lord.
But we had provided.
You have given an email, my lord, indicating, my lord, names of 3 schools.
Yes, Mr. Rai, what is your instruction?
My lord, I'm sorry, my lord. Lordship was right that these persons are not in talking terms. The father and mother.
Two advocates, they are in talking terms.
They are. So, my lord, I have been, my lord, advised, my lord, so that I actually apprise your lordship.
Take your seat, you take your seat.
No,
You are running from somewhere else.
So, my lord, here,
yes,
there are 4 English medium schools and 1 Bengali medium school, my lord, they have offered. So, when all those schools are situated in Berhampur, so which is, my lord, 20 kilometers away from my residence in Jiaganj. The kilometers that they have mentioned, it is
in
common.
Jiaganj. Yes, Mr. Partha Pratim Rai.
But all good schools are at Baharampur, my lord. We all know, my lord, all good schools are at Baharampur.
But Mr. Mukherjee,
And
the
that- may I just-
distance from the residence
I have the
to
Google.
borrow
But I tell you, Lordship, Milord, the distance is Milord 10 to 12 kilometers.
school, reputed school in
There-
Jiaganj,
there is one.
Bengali medium
There is one.
or English medium.
New school has opened in Jaganj, a new one.
It's English medium or
No,
Bengali medium.
I tell you, Lordship, there is another. So I have been, my lord, informed that, my lord, it is Shripot. কি নাম?
Jaganj Vijay Singh.
আমাকে বল। জিয়াগঞ্জ?
Raja Vijay Singh.
মানে Raja Vijay Singh Singhi High School, which is known to be a Shripot Singh school. It is a very old school, one. And second, my lord, the new situation, because it has been, my lord, the infrastructure and everything are being developed by one foundation, Tatwa Mashi, which is of the singer Arijit Singh.
Arijit Singh school.
Yes.
Arijit Singh school.
That is being.
That is
Or most of the schools are there.
where is the name? Where are the names, Mr. Dotto? Where
I
are
have
the names
also-
you have given?
I have also, my lord,
Please show it to Mr. Rai.
my lord, print out. No, I have this copies, my lord. I have, my lord, got this printout of the, my lord, distance from the Google Map. That will be evident. 27.4 kilometer, 23 kilometers.
Yes, Mr.
I have the Google Map.
Mukherjee.
My lord.
Distance is 23, 27 kilometers. It might be difficult for the child to travel from the residence to
My
that.
lord, for a good school, Lord, the child has to, because Lord, of the residence of the
Has to, that is one thing. But the distance factor and that is also to be taken into consideration.
yes, but Lord, it will not take more than 40 minutes, Lord, to travel. Because Lord, I am told by my client, even in that letter, Lord, the travel time has been indicated.
Mr. Mukherjee, 23 to 27 kilometers cannot be covered within 30 minutes.
But I have every doubt about Lord, the distance that Mr. Rai is saying. Because Lord, in our letter, Lord, we have stated about the distance.
Parthapratim Rai, not Mr. Parthapratim Rai.
ভয়ের মধ্যে আছি।
Not Mr. Parthapratim Rai, Mr. Ujjwal Rai.
Yes, Mr. Because Mr. Rai comes from that locality, he knows the locality very well.
I know, Lord.
Yes, Mr. Rai, can you assist considering the names? The child is at present studying in one of the schools in Jiaganj.
Government school.
But he is
Yes, in a government school at Jiaganj. The father wants him or her him to be admitted to another school. Better school. Father has suggested some names of English medium schools
And three of
and also one Bengali medium school. I think mother also has some suggestions with regard to some schools. Can you please assist the court as to which of the schools can be? And the student, the child is now in a Bengali medium school in class
Five.
Class 5. And that is a private school. That is not a government school.
It will be difficult to transfer in an English medium school from 5
Yes,
onwards.
this is exactly my instruction.
But Kali consider it that way also.
Now he's almost in 6.
Not now, he will never be.
or Bengali medium, any good school. Please
given
consider
three
that. Please give the names.
We have given them.
Can you come back at 2 p.m. or tomorrow?
I'll come back tomorrow.
Tomorrow.
Out of these 3 Bengali schools,
We have.
who accumulated?
But the Ramakrishna Mission is there. The Ramakrishna Mission is there. Lord, the first name is Ramakrishna Mission.
Where?
Sargachi Ramakrishna Mission, it is between Beldang, Bhapta and
Yes, that is Lord, what we are Lord, suggesting.
What will be the distance between the residents? Please take it.
Jiaganj to Sargachi, it will long distance. After crossing Behrampur, it will Sargachi.
To a long distance, Mr. Mukherjee. That is
Is concerned. So the JN Academy is concerned, it is near Khagra, where I have also done my schooling from 9 and 10. So
Laduram Tosniwal.
that I
Second one.
Please, I'm keeping it tomorrow. Please consult, both of you give the names so that Mr. Rai and also the time it will take.
But also, my lord, let them. May I just complete my instruction and thereafter, my lord, whatever my lord and senior my lord will be doing.
আমি কিছু করেছি।
No, my lord, for the husband, the father. So, my lord, first, my lord, the incumbent, this child, my lord, actually was my lord inducted in the Bengali medium school.
All right, I will consider that. Let me get the names of the school.
And also, my lord, the name that we
There is always scope for better school. Because he was admitted in one school, that he should continue all his academic years in that school. That doesn't mean.
Name to Mr. Dotto so that he can communicate to Mr. Mukherjee as well as to Mr. Rai. Both of you give the names.
Vijay Singh ke naam ta portal likhe.
This puts Bengali school at Lalbagh.
Please consider the distance. Please
Please
consider
suggest that also.
at the place of residence.
So
of
far,
the-
the Lalbagh Nawabad institution is there. There is the oldest government school.
Yes.
There is the only, initially it was the only government.
Mr. Rai, can you do one thing? Can you give the names which according to you would be the best, considering the welfare? Can you intimate
why.
it to both of them in course of this day at any point of time, so that they also can take instructions tomorrow? Please, I am keeping it under the same heading. Please try to be present. Mr. Rai has to also consider that. Mr. Rai will consider that. Please give him some time.
I mean,
Because he knows the locality very well, and also some of the schools. That is why I'm appointing a neutral person who will be the best person to.
এখানে রেসিডেন্সিয়াল আমি ছিলাম সাইকেল স্টেশনে
And he knows the location, the distance also. He will be the best person.
এইগুলো সবই হচ্ছে বলতে বড়পুরটা ক্রস
And if both of you want, I can appoint Mr. Rai as the mediator for this.
Kindly do that, Manoj. Kindly do that.
Look, yeah, we welcome that. We'll really welcome that.
Kindly do
So
that.
far as the matrimonial dispute, my lord, that we will welcome Mr. Rai to mediate.
Nothing more.
And so far as the child is concerned,
for the welfare of the child.
Great.
So,
দাদা এটা থাকো সিরিয়াসলি দাদা আদারওয়াইজ আমিও বলতাম
the parties are agreeing.
নাহলে আমিও তুমি কাইন্ডলি ডু দিস
Consider list this matter tomorrow under the same heading.
My only, the father's only apprehension is with regard to the government schools, considering the present situation, there may be
Mr. Dotto, have some faith in Mr. Rai.
Lord,
He is from that locality. He knows.
he knows everything, but
Yes,
considering the
he will
present
he will be having a chance to discuss with Mr. Rai.
and we would also consider the mediation part, that mediation, my lord, between the parties.
That is informal mediation, Mr. Rai. What Mr. Rai, Mr. Mukherjee, what Mr. Rai is doing.
ওইখানে বসে বসে
Not the other dispute, only with regard to this for the present.
Very well.
Yes. Yes, for the next matter.
চারটের সময় ফোর একটু ফোন করে নিবি না আমাকে দিয়েছি কত this is why the amount that your logically consider the সেটা আগের যশোরে দেখেছি ওনারা বললেন যে আজকে আমি ইয়ে করলাম সেটা
Yes, Mr. Rai.
The lost order passed by your lordship, my lord. So for the merits are concerned, my lord, I am not on that. The amount is due, admitted. I have taken the loan. I want to.
What is the amount?
My learned friend is supposed to hand over.
You have not given it to him.
I have given his clerk, my lord. He might have not given him, my lord. আমি রাজুকে দিয়েছিলাম একটা
কাকে?
রাজু ওর clerk.
Raju.
There are two accounts, two separate accounts on the same name.
Where is the chart? Why have you not prepared a
Second page. Last page. Can you see both the last page?
In which bunch?
Anyone with the two loan accounts. Can you see top of the heading Corporation Bank? First page Corporation Bank. Can you see top?
আমাদের কোনটা
First page Corporation Bank.
Can you see the last page, last line?
Union Bank.
আমাদের তো Union Bank.
We are considered the Union Bank.
Give me a second.
Union Bank.
What happens is this Corporation Bank and Andhra Bank merge into the Union Bank of India. That is why there is no these banks now.
All right, give this statement. Yes, Mr. Rai.
আমাদের
Union Bank.
না লোনটা কোনখান থেকে
When can you tomorrow?
Tomorrow, my lord. I'll go through it tomorrow.
Let him go through this because
PM, if possible. It's possible by 2 PM, if possible.
Tomorrow.
Yes.
I'm keeping it if there is a difficulty because now I do not know because you have seen some mentionings that there.
So this goes without saying, my lord, this corporate
No,
bank
yes,
and
yes,
Andhra Bank
yes,
merged into the Union Bank. So these are the loan account statement.
Right.
I have given him.
লাল আছে হ্যাঁ লাল সব জানে
Tomorrow.
Tomorrow at 2 we mentioned.
Let it appear tomorrow.
I'm
Yes.
grateful.
Let the time be flexible. Yes, next.
Any.
Wait, please. Appearing on behalf of the opposite party, my lord, in this matter.
Yes.
Commissioner, I have served, my lord, the opposite party. My lord, I am praying for fixing a date, my lord. The matter relates to, my lord,
It's appearing in the list.
yes, I am praying for today extension of interim order.
Just expired in March.
Yes, we have filed in time, my lord.
The application.
Yes. Oh,
Where
it
is-
has been filed on 9th of April.
Not within time.
No, no.
Where is that
I-
application? Where is that application?
Can talk also.
Can 1 of 2025 কোথায়?
My lord, the matter pertains to, my lord, preliminary degree, my lord, suit, partition suit was filed by the plaintiff.
You are for the opposite party. So I'm extending it.
My lord, I'll be humbly praying for an opportunity to make an opposition to this, your lordship.
To the main civil division application. Why? What for?
But certain facts are not disclosed here, your lordship. I'll just
All right.
get that, my lord.
Can disposed of.
Fine.
Yes, next. Yes. Affidavit.
Yes, affidavit complete, my lord, and my lord,
Service.
yes, service, my lord, I have also got the track report. All have been, my lord, served.
Served. Ashun, can 2 of, what is can 1?
No, can 1 disposed of.
Can 1 disposed of?
First, application for extension of interim order.
Oh, can 1 disposed of তাও দেখাচ্ছে। Can 1 disposed of? Ashun, can 2 of 2025, this is an application for extension of interim order. First of affidavit of service filed in court today is taken on record. First of can 1টাতে দেখুন, uh, record reveals that can 1 of 2025 was disposed of by an order dated
appeal course.
Seven.
Then I beg to
Number
appear
seven, my lord,
of
I
the
am appearing on
petitioner.
behalf of the opposite
This
party.
formal extension of interim
I am
order, my lord.
opposing.
It
This
is can 2 of 2025. What is can 1?
one dispose of earlier
কি
application.
হয়েছে সব নোট করছেন না নাকি?
Earlier application.
Opposing this application, my lord, the execution proceeding has been stayed. My lord, my landed senior friend has filed the application under section 47. That was also rejected. My lord, all the application, the
my lord,
recalling was also
Isn't
rejected.
that posting it after the vacation?
My
Lord,
lord, the
that is
problem
not
my lord,
correct.
I am suffering,
That
my lord.
his case
I am
is my lord
suffering.
pending.
Because my lord, the police self
Listen,
was
I'm
allowed.
fixing the matter. I will hear you. This ক্যানটাও সেম। এই ক্যান 2টা কিন্তু ডিসপোজড অফ। ইয়েস, ক্যান 1টা তো সেম অর্ডার করে দিয়েছে। ওই অর্ডারটা দেখে নিন।
Hello, this is my application. Lordship, may recall yesterday, my lord, this is an appeal from an order of the DRAT, I told your lordship.
Yes.
Issue was, my lord, without considering my condonation of delay application on the ground that pre-deposit has not been paid, my lord. Even though my application for dispensation of pre-deposit was not on board that day, my appeal itself was dismissed. From that, I have been constrained to come up before your lordship. My lord was of the opinion that, my lord, if the appeal itself is non-necessarily, as on that date, no interim order can be passed in my favor. Lordship is pleased to remand it back, my lord. I will be satisfied, my lord. I will seek the necessary interim order before the debt recovery appellate tribunal, my lord.
Court has no reason to entertain this situation.
Why?
Because, my lord, order passed by the
Not the original order. He is challenging the order under section
appellate tribunal.
Appellate tribunal rejecting section 5.
He should challenge this his order before the Guwahati.
Before Guwahati?
My lord. This is the
My lord, the debt recovery tribunal Guwahati had passed an order, the recovery certificate. We went up against that before the appellate tribunal. That is the Kolkata appellate tribunal.
No, for there is no appellate tribunal in Guwahati.
My lord, Guwahati determination is being entertained by the High Calcutta.
Oh, that is
recovery appellate tribunal. Copy that. Citation document.
Yeah,
AIR.
Have you considered this judgment? AIR 2002 Calcutta.
Oh, my lord, I'm not favored with a copy. In that case,
the reported judgment AIR 2002 Calcutta 223. Where is Mr. Shah?
My lord, he is on legs. Yes, my lord, yes, my lord, but he is on legs before court 41, I'm told, my lord. Maybe come back after the vacation in that case, my lord.
And I think we will be getting the Supreme Court judgments also on this in
My lord, the
income
proposition,
tax or central excise matters, where tribunal is situated in one state,
yes, my lord.
but the appellate tribunal is, or the assessments are made by the officers in one state, but the appellate tribunal is in other state.
My lord.
So the issue is whether the High Court at Calcutta or the High Court, where the original assessment proceedings are pending, would have jurisdiction. Supreme Court judgments
My
are
lord, to be
also
honest,
there. You
this
can-
is a point that I have not really considered, my lord. In that case, if your lordship will allow me to come back either tomorrow or after the
I
vacation.
think after the vacations, please consider this.
My lord, the interim
Because,
protection though, my lord, that was subsisting.
That was
That
subsisting,
is the
no matter, but
difficulty.
you now considered that to go back without the interim order.
Yes, my lord, I am happy to go back without the interim order, but in that circumstance, I would be able to approach the debt recovery appellate tribunal for the interim order. But if the appeal languishes here, but the interim order is vacated, I cannot press the appellate
But
tribunal for the
the
interim
fact
order.
is, if this court does not have jurisdiction, it cannot also pass any interim protection. Yes, Mr. Shah has come. Yes. Slowly, you need not rush. Mr. Shah, one difficulty. Yesterday, when you learned junior moved this matter, there was a point which was troubling me is that if the Section 5 rejected, appeal is non-est in the eye of law.
Interim order cannot continue.
Now, the other problem is, it's the tribunal is at Guwahati and the appellate tribunal is at Kolkata. Your learned friend is relying upon a decision saying that this court cannot have jurisdiction. It's the High Court exercising jurisdiction over the tribunal will have jurisdiction.
I understand the point.
That is one. This is a coordinate bank judgment, year 2002 Calcutta. But the Supreme Court judgments are also there under other statutes in Income Tax Act, Central Excise you will be finding.
No, I quite appreciate.
So
kindly keep it after the vacation. Let me
after the
consider it.
vacation.
Yes. Thank you.
Ashun. You will be finding in the other acts. Income Tax Act, there was these decisions are there.
I will check up. I will check up and come back.
Assessment officer, assessing officer of one state, tribunal is in the other state. So the issue arose, which High Court will have jurisdiction against
I
the
was
order?
only wondering, my lord, because the order impugned is, my lord, the order of the DRAT, which is Calcutta based. My lord, I wonder whether your lordship, but let me check up.
Yes, that is one thing, and that is the similar thing with regard to Income Tax Appellate Tribunal also.
I will check that.
From that, so that is the issue
No,
of jurisdiction. This is a single bench judgment of our court. I do not know whether any division bench judgment is there. You can check up. And Supreme Court judgments I know are there.
I will check
We
it
in
out.
the division bench has considered that and passed
No, let
orders.
me not make any guesswork. Let me read, educate.
Those are
myself and come
in
back.
revenue matters, Income Tax Appellate Tribunal or say stat, whatever it
No,
might.
I will check it up.
It's an interesting issue altogether.
Yes, my lord. Lordship has kept it on 10 June, not very, my lord, late. We'll come back.
Thank you. Yes.
9 and 10.
Item number 9 and 10, my lord, that is that matter, my lord, regarding the
which matter?
Well, execution is filed in 2010, my lord. The record was misplaced, and I mentioned
reconstruction of records.
Yes,
records have been reconstructed, Mr. Ghosh.
My lord, your lordship's intervention, my lord, my lord, it will be a blessing to my clients, my lord. 2010 application matter was pending 2022. 1998 suit on the ground of reasonable requirement. My lord.
Dekhan report.
Grateful to your lord. Your Lordship can direct the matter to me.
But please check up because the date has been fixed for verification. Any day the date may be fixed. Please take
Yes,
steps.
my clients are here, my lord.
The
22, my lord, I'm running from pillar to post. I'm
And
grateful.
after your lordship's intervention, the
My lord,
advocate is being
my
called
I
by
asked
the district judge. Thereafter, the learned advocate who is conducting our case before the trial court, he has been called for by the district judge. And thereafter, everything has been narrated and this has been.
Yes, next.
11 to 13. My applications. If you recollect, this issue involved was the suit was valued at 1,65,000. An appeal against refusal of an order of injunction was preferred before the district judge, admitted, and status quo order passed.
You are appealing for the opposite party, yes.
I am for the opposite party.
Yes.
Our contention was it
Your
was
submission.
wholly without jurisdiction. And our submissions are recorded in my lord's order of 7th May 2025.
7th of
My lord, I am also there,
Mr.
but
Chat.
allow Mr. Basu Malik, my lord, to make the submission.
Where is Mr. Chatterjee?
My lord, I am before your lordship, my lord.
Somewhere on earth.
I cannot see you, Mr. Chatterjee.
My lord, my video has conked off, my lord. I cannot do anything on it.
Before me, Mr. Chatterjee.
My lord,
You are not before me. I cannot see anyone, any Mr. Chatterjee before me.
I am before your lordship, my lord. My voice is there, my lord.
You are audible, Mr. Chatterjee.
My problem is with the video, my lord.
With the
video is not working. Kindly have a look at the plate, my lord. Everything, my lord, would be.
You say, have you seen the order dated 7th of May 2025?
Yes, I have gone through the order.
Yes, what is your submission?
The petitioner has already filed a petition under section 151 of the CPC before the fast track court at Barakpur, and that is in the on the same objection of jurisdiction. That petition is now pending.
Maybe
The matter is June.
what remains, especially if it is barred, nothing remains to be decided on that application. Show me that the court has jurisdiction to decide the miscellaneous appeal. Please satisfy me on that. Unnecessary matters cannot be.
It has been valued excellently by his profit. It has been the value.
Yes.
Only the
Yes. So, value of the law. If it is the value of the eviction is 200, it will be considered, or the total valuation will have to be considered. You have not raised any objection of the valuation before the learned. That there is a decision of the court.
I have raised the valuation in the written statement that has been filed in the trial court in Bharat.
But till it has not been decided, the miscellaneous appeal is not maintainable. What affidavit in opposition, sir? So it's the point of law. What affidavit?
I am
Kindly stop stays the operation of the order, my lord.
giving the valuation of the suit.
All right, I am staying the operation of the order. You file your opposition according to your own.
Grateful to your lordship.
If after all your appeal, I can direct you, I can give you liberty. Sir, if it is not maintainable, if it is not maintainable, what will happen?
The appeal court can also decide upon the jurisdiction of the maintainability.
I could cannot.
I'm just saying for one.
Asking you, you have your submission that the
submission that
appellate court has jurisdiction.
My submission is that I am praying for opportunity to file affidavit in opposition.
So it's not a matter of right that you will ask and you will be granted an opportunity. For what? It's the point of.
I have to challenge the valuation of the suit.
Do that before the trial court, not here.
I
do that before the Yes. Pursuant to the
এখানে সুট ফাইল সাপ্রেস করছে এটা সাপ্রেস করে অ্যাপিল করছে
application up in the event of the
He wants to
expiry.
file affidavit, so it has to be a contested application.
Well, this appeal needs to be dismissed. Well, this appeal is required to be dismissed. Well, I was also carrying a
I've
listed
stayed
case.
that. You are not affected. Interim order has also been stayed. How are you affected?
I'll tell your lordship what is happening. Well, the petitioners before your lordship are developing that particular plot of land. Well, by
Mr. Shah, you are for the opposite party.
আলাদা অ্যাডমিট হবে
অ্যাডমিট হবে
অ্যাডমিট হবে দুজনে
আমি বলে যাচ্ছি তাহলে অ্যাডমিট
বলছি অপোজ করলে অ্যাডমিট হবে
সিটিং
order 7
order 7
order 9 rule 13 rejected by both the courts. Only one thing I draw your lordship attention.
You have no case, Mr. Rai. Both the courts, you could not succeed.
One can you turn to page 19 once.
19.
Though it is
What is 19?
the expiry degree.
Yes. For that you have filed order 9 rule 13.
Expiry 2 lines.
Maybe. Mr. Rai, can it be gone into in order 9 rule 13? Could have preferred a regular title appeal. That is also permissible. This can be gone into there.
And what are the other grounds, my lord? If you lordship, I'll turn to my application, page 23, relevant portion.
Tell me, what are the grounds?
That it was papers are handed over to one of the London advocate of this honorable court also, Mr. Malik. And the person who is contesting the suit is the widow of the original tenant. Widow of the original tenant.
Yes.
According to both the court's finding is that the summons was served, so you have the knowledge. So you cannot say that you have no knowledge about the proceedings. But my case is that after handing over the documents to Mr. Malik, he was taking all the steps in this matter.
Subsequently, he
passed away. After that, I inquire and find out some documents and hand over to newly engaged advocate. Subsequently, the court is of the opinion that the signature Mr. Malik or Vakalatam is not appearing in the records. So far the statement made that papers have been handed over to Mr. Malik does not appears to be true. But another advocate's name is there. So these are the findings on basis of which manner both the courts will have held that there is no ground for
suit for eviction.
Reasonable
requirement. Reasonable requirement.
And default 1995.
From the non-challenge evidence granted, the evidence that even is a default.
What do you want? Some time. You want some time.
Yeah.
Want some time.
That instruction is not with us at present. I don't know because this is the grounds for the purpose. Now,
this is the finding of both the courts below.
That you have the knowledge about the proceedings, so you cannot say that.
So it has come out in evidence.
If your lordship can turn to the municipal court, my lord, judgment.
Yes, Mr. Shah, what do you say?
Considered by the court, what, according to your lordship, that is the
finding of the appellate court. On merit, if you can find an
Ex parte degree order 9 rule 13.
what is his case? Someone was not served. Evidence is contrary. He received the summons, appeared in court by filing Vokalatnama. And he is saying here in order 9 to 13.
When this type of matter comes, one matter comes to my mind. Mr. Rai may be aware of that GNK drugs.
Even if I am constant to cite that judgment.
If the losses looks to the paper,
I'm telling you, everywhere, my client succeeded, was the landlord, everywhere.
There is nothing to interfere with the order impute, but it is this our court is of the opinion it should be heard out on merits.
No. Here also I succeeded.
Here, Honorable Apex Court.
But thankfully, the what saved the client was one list of dates, which I produced at the time of hearing. That was part of the order impugned. And just before the recess, it was said that it will be remanded. After going through that, it was that ex parte degree was saved. That's why I'm asking you.
JNK drugs.
JNK drugs. I am telling you because Mr. Rai must be knowing well for that. What do you want?
No, this is not a case where court will interfere. This is not a case where court will interfere.
Can you turn to page 5, internal page 5, the appeal court judgment? The first paragraph and the last paragraph are by
page 5 of the appeal court judgment.
Because what it is merged with the appeal court, I am not drawing law sentence or the trial court is concerned.
Page 5, yes.
Internal page 5, there is nothing, I have got it.
Yes, there are nothing.
There are nothing.
Not is. Are.
There are nothing. On record to support the plea of the petition that the summons were not duly served on them.
That was also your case.
Yes.
So you have made twofold cases. Mr. Rai, there is two things. One is non-service of summons.
Non-service of
Another
summons.
is appeared, subsequently disappeared for certain reasons.
I am only
you are saying that subsequently that you have handed over papers that so summons were not served. You have also taken that.
That is why, because two proceedings were there. One is the probate proceedings of my brother. Another is this eviction proceedings. That is why, my lord, from the application itself, these eviction proceedings documents are not with me because after the death of my husband, those documents are not with me because my husband handed over all to Mr. Malik. Now, my lord, when the probate proceedings started, I got that documents because it is in favor of me.
All right, place this. Yes.
Appears to the order sheet that the substituted defendant number 2 and 3 entered appearance of file in Vokalatnama such and such. Apparently, summons was served long before the marriage of the defendant number 3. Defendant number 3 is one of the daughter, my lord. After marriage,
so wife and one daughter.
One daughter, son.
Son is also there.
Yes.
Yes.
She is the daughter. After marriage, she is I am not on that. When confronted with a copy of the summons dated 4/4/2016, which was addressed to her and returned after service, the PW1 in her constitution admits her signature.
You did not place the entire. What is the infirmity, Mr. Rai?
This is the thing, my lord. Now, my lord. So this is the findings of the learned court bill on the basis that yes, I have received the summons regarding the knowledge of the proceedings.
So summons was served.
Now, my lord.
So that part goes. So you have to now succeed on the other part.
That is what I have done, Lord.
Yes, show me that.
Further, the last paragraph, my lord.
Yes.
Is that the petitioner engaged advocate such and such to defend the case and the matter faded away from her memory, and the learned advocate also did not apprise her anything about the suit. The PW1 in her constitution stated that she empowered advocate such and such to represent them in the original suit. She adds that she cannot recall whether Vokalatnama was signed or not. This plea also does not find any support from the materials on record. There is nothing on record to show that the petitioner engaged such and such to defend the case. It appears from TCL that the trial court record that the petition number 2 and 3 engaged Somnath Dan to defend the suit. The Vokalatnama filed by C. Somnath Dan is on record. In her constitution, in petition, as Peter stated that the said Vokalatnama was filed on behalf of her son and daughter. It further appears that the said advocate filed the miscase under Order 9 Rule 13. The PW1 also affirmed it. So, plea of the after date of such and such petitioner number engaged senior lawyer, and only after they came to know about the said suit was dismissed for default is doubtful. My lord, pause here for a moment and my lord kindly consider.
where the inference which was drawn by the learned court below, that as if the learned advocate who was
Where is your application under order?
ordered Rule 13. That your lordship will find at page 20. It's relevant portion is page 21. I am drawing your lordship attention to over the paragraph 6 onwards, page 21.
Who was your learned advocate before the in the miscellaneous case?
Mr. Gautam Banerjee. No,
So please come to page 26, affidavit part.
Page 20.
6, affidavit part.
It was Somnath Dan.
Somnath Da. So he was the advocate who was engaged by you in the suit also.
He was participating.
Yes. So if that is so, Mr. Rai, your case of engaging Mr. Mollik goes.
Only was
there. Mr. Rai, here is a case. The self-same advocate. It's not your allegation that he did not. So the advocate, according to you, it appears from the Vakalatnama that Mr. Da was your engaged advocate on record before this suit court. Now, if you are not happy with him, you would not have engaged another advocate in miscellaneous case, but it appears from the record self-same advocate.
This advocate which was there in the original suit is
Yes,
participating in
Mr.
the
Rai.
present.
Anything more? Thank you. Ashu, this application Yes, call the list.
My lord, in this matter, I am on behalf of the petitioner. My lord, the petitioner have instituted a suit for eviction of licensee khas possession and main profit in the year 2011 before the learned civil judge, Junior Division, 3rd Court at Srirampur. Thereafter, all on sudden, my lord, the opposite party has instituted a suit against the petitioner in the year 2022 for declaration and permanent injunction.
What is the stage of your suit? Eviction suit?
Eviction suit is a PH stage.
And the other suit?
Other suit, my lord, kindly. Others should also be date fixed for PH.
So same stage, parties are same.
Parties are same, scheduled properties are same. My shoot is earlier shoot.
Both can be consolidated.
My shoot is before the civil judge 3rd court, civil judge Junior Division 3rd court, and their shoot is the 4th court. If your lordship kindly allow to convert the to analogous hearing, the board should analogously and
you have to serve then, otherwise.
Yes.
By the order impugned, the application Yes, Mr. Manna.
My application will not. I will serve the.
Please use the microphone.
And I will serve the respondent.
That you will serve. Please show me what is the impugned order.
Impugned order, lordship, kindly come to pay.
Yes. Yes, what is the order impugned?
Impugned order will come to page.
Mr. Manna, please adjust the microphone. Yes.
Lordship, kindly page 70 is.
What is the order impugned, Mr. Manna?
Yes. The gist of the order is page 70.
Yes, what is the nature of the order?
Lordship, page 66. Page 66.
Yes, tell me what is the impugned order?
Impugned order is, lordship, the petitioner, before your lordship, he got the land by a will, my lord. Will. But attesting witness it is Sukumar Das. But he, after death of my lord, they will made will that he filed an application for probate and or administrative later administration. But the opposite party may not filed objection petition denying my this will, my lord. Then my lord, the Sukumar Das is attesting witness, my lord. He is not appearing before the learned court.
He is not appearing.
Not appearing.
He has not deposed.
Deposed. So
what do you say?
So lordship, kindly come to last page 70, my lord. paragraph.
No, Sukumar Das is PW3. He has deposed. What are you saying? He's PW3. He has deposed.
But he is not giving the sign, signature.
That is a different thing altogether.
Signature.
That is a different thing. He appeared, he deposed. So you want to collect his signature.
Lordship.
What you will do with that
The
signature?
appointment of commissioner, the earlier order is passed, my lord.
No. What you will do with his signature?
Signature, my lord, he is not, he is denying.
Mr. Manna, you have to prove the execution of
He
the
is
will.
denying his
Yes,
signature.
for
So
that,
it is due.
merely Mr. Manna, merely by proving the signature, will cannot be proved.
No, he is denying.
Yes,
denying his
there
signature.
are other evidence. You have to prove, Mr. Manna, you have to prove by other means, not by way of
No,
handwriting expert.
the court is saying that this is not Lordship, kindly see. Since the Honorable High Court earlier moved moved an application and order was passed, my lord, directing the landed court, my lord, to dispose of this within a period, my lord. So this my application is not been considered.
Yes, there was a direction only to dispose of. What is wrong in this order?
Wrong. This signature is necessary. He is not putting his signature.
You cannot force a person to prove his signature.
No, it is otherwise how my
that is up to you how we will prove. That is for you to take steps.
Only this person is a attesting witness.
No, there cannot be one attesting witness.
Only
At
this
least two attesting witnesses are to be there.
My lord, kindly matter be pending, my lord. I give the notice to the other side, my lord. On contest, my lord, it has been heard.
Not contest. Please satisfy me for service. Service is not automatic, Mr. Manna.
And I will satisfy, my lord. Are you satisfied? In presence of one other side, it come. They have nothing.
Other side need not come. In their absence, please
The
satisfy.
other side has no right in the land in question.
All right, that will be considered in the probate proceedings.
Probate proceedings.
Probate court also cannot decide the title. It only decides whether the will was validly executed or not. Nothing more than that.
Today, this cannot be decided, my lord. Today, only this motion period, my lord, without notice. So I pray before your lordship, my lord, I would serve the notice, my lord.
No, nothing. Asun, this application.
Otherwise, my
17.
17, Your Lordship, Mr. Bhattacharya is appearing on behalf of the petition.
Since I'm not inclined to take up this matter on personal ground,
I am for the petitioner.
yes.
My lord,
Yes, Mr. Ghosh.
my lord, the opposite party number 1 herein, my lord, by practicing fraud, my lord, the executed.
Haripur Court, do I have any difficulty in taking up?
No, no.
Yes.
My lord, the executed a will and my lord, the filed application for probate before the learned district delegate, my lord, to obtain that probate. My lord, I being the legal heirs, know my lord, the citation issued my lord, the against all the legal heirs. My lord, I filed an application for revocation of that will and my lord, pray for my lord, stay of operation of that order passed in the probate case. My lord, the learned trial judge by the impugned order, my lord, the held since the paper publication was made, it was notified. So I ought to have my lord, the appear before.
How stay can be granted, Mr. Ghosh?
That is my lord, the injunction, my lord. That's true, my lord, but my lord, otherwise, my lord, if my lord, the probate order is effected in the meantime, my lord, that
Probate has been issued, probate has been granted.
yes, yes.
So you have applied for revocation.
Yes.
So
In-
how
in-
can that be stayed at this stage?
my lord, in connection with the revocation application, my lord, I have filed an application for stay of operation.
How can that be granted, Mr. Ghosh?
So,
Contested, month list of July, yes.
19. My lord, I appear on behalf of the petitioner.
Please adjust your microphone, Mr. Mondol.
My lord, I am the defendant in a suit for declaration and permanent injunction. My lord, the opposite party as plaintiff had filed as application under Order 39, Rule 1 and 2, ex parte ad interim rejected. But thereafter, they have preferred the misappeal. Now, my lord, kindly, my lord, comes to page 36. That's the order of the misappeal.
You have not annexed the certified copy, Mr. Mondol. You are challenging the order passed in miscellaneous appeal.
No, my lord, I am challenging the order in passed by the trial judge, my lord. Civil Judge Junior Division, 7th Court.
Which order you are challenging?
3rd of April. 3rd of April 2025, my lord.
Injunction order, how revision is
No,
maintainable?
my lord. Yes, my lord. I am coming, my lord. That's why, my lord, kindly, my lord, comes to page 36, my lord.
Yes.
36, my lord. Now the operating part, my lord. That the misappeal number 205 of 2017 is hereby considered allowed on contest, but without any order as to cause. The order dated 7th of December 2017 passed by the Civil Judge Junior Division 7th Court, Howrah, entitled is set aside. Both the plaintiff and the respondent number 1 are hereby directed by an order of injunction to maintain status quo in respect of possession of A and B scheduled property as on today till 3rd of April 2025. And respondent number 1 is hereby restrained from making any unauthorized construction over a scheduled property without sanction plan from HMC till 3rd of April 2025. Now, my lord, on 3rd of April 2025, kindly, my lord, comes to the impugned order, my lord. And my lord sees, record is put up today, part record is tagged with the original record. Plaintiff had filed Hajira along with a petition praying for extension of the interim order for injunction. Now, the defendant filed 2 separate petition praying for filing WS and WO on the ground stated therein. POE is transferred from this court. Case is adjourned.
This is an appellable order.
Now, my lord, there has to be a substantive order, my lord. Kindly, my lord, sees the trial court, the Civil Judge Junior Division is extending the order of injunction passed by the district judge.
Can you not take that point in an appeal?
Yes, my lord, I can take, my lord, but kindly, my lord, say apparent lack of jurisdiction, my lord.
Why? The miscellaneous appeal.
Miscellaneous appeal.
Mr. Mondal, miscellaneous appeal was disposed of by passing an order of status quo till 3rd of April.
3rd of April, yes.
So the learned trial judge has extended that.
No, my lord, learned trial judge does not have the jurisdiction to extend, my lord. He ought to have applied before the learned district judge for extending the order of injunction.
Miscellaneous appeal has been disposed of.
Yes,
that is the question of extension.
Yes, my lord.
This miscellaneous appeal was against the ad interim order.
Ad interim ex parte.
So ad interim ex parte.
Yes, my lord.
What was the initial ad interim ex parte order?
That was refused, my lord.
Yes. So
refused.
So initially refusal.
Yes.
After that refusal, you went before the appellate.
I know. The
They
opposite
went
party.
before the appellate court.
Yes.
Appellate court passed an order of status quo.
Yes, my lord.
So that was still limited period.
Yes, my lord.
So now the trial court in the line of the order passed by the appellate court has extended.
No, my lord. How can the trial court, my lord, the extent passed by the first appellate court, my lord?
This is
My lord,
this order is binding between the parties.
Yes, but
This order is binding between the parties.
That order remained effective till 3rd of April 2025.
Yes.
Now, my lord, the learned trial judge is extending, my lord, the order passed by the learned district judge.
No. It's differently couched. So where was your application for objecting this prayer for extension of the interim order?
I will not get that.
If you have not opposed, that was extended in similar lines. I can clarify instead of extending that order. So this should be construed to be order in terms of that.
No, my lord, then only, my lord, on 25th of June is the date fixed for injunction application hearing. On that date, maybe injunction application may be heard out.
That prayer is a justified one. After some argument, Mr. Mondol, advocate, Yes.
20 plaintiff is the petitioner before my lord suit for declaration, recovery of possession and injunction. In such a suit we file an application order 39(1) and 2. The learned court below passed an order of status quo directing both the parties to maintain status quo. That was violated by the defendant. We file an application 151 for implementation for police help. That was rejected by the learned court below. I preferred divisional application before this honorable court. This honorable court dispose of this application, giving liberty me to file an application under 39(7) for local.
39(7) what for?
For local inspection. Thereafter, the ascertaining that kindly comes
that order.
Page 52. Page 52 the paragraph 7 accordingly the divisional application is disposed
Page 52.
Page 52 server copy of the order.
How many times you have annexed the same order, Mr. Ghosh? Page
that-
59 also that order is there.
That is the along with the application before the learned trial.
One time separately, again along with annexures. Yes. Yes, page 52.
Page 53 accordingly divisional application is disposed of with direction and with the direction and liberty granted the petitioner to file an application on order 39 rule 7 CPC before the learned trial court and land court. On hearing the parties shall allow the prayer for local inspection which is to be completed such and such. Now with this liberty I file this application.
Where is your application under order 39 rule 7?
Page 55. Point of local inspection given. Prior to that kindly comes to the schedule of the plane.
I will come to that. Let me see the point number 1 cannot be allowed. Point number 2 also nothing. All these are fishing out of evidence, Mr. Ghosh.
Now kindly comes to the plane.
Yes. Your suit is for declaration of title and for permanent injunction.
Recovery of possession. Kindly comes to
Your case is that of encroachment.
Yes.
Show me, however, describe your encroachment in the plaint.
Kindly comes to
Show me the sketch map describing the encroached portion. And even if there is a case of encroachment, can an application under order 39 rule 7 encroachment can be decided, Mr. Ghosh?
Kindly comes to page 19.
I'm asking you, assuming yes, it's a case of encroachment, can an advocate commissioner decide the issue of encroachment?
In the meantime, he is making construction.
No, that is the other thing. You have said encroachment. For removal of encroachment, I'm asking you, order 39 rule 7, advocate commissioner can decide on the issue of, can give a report on the issue of encroachment. Yes.
Page 16, my lord.
Yes.
Page 18, the schedule of the. I am the owner, my lord, in respect of LR plot number 6084 and 6088. Kindly comes to the cost schedule. Cost schedule, my lord, 6088. Property belongs to the plaintiff, and my lord, 6084. 6085. The property that belongs to the defendant. Now kindly see the sketch map, the some the mark portion that is within my plot number 6088.
Mr. Ghosh, your plane does not make any sense. Yes. What is your plane? Prayer co, you are saying that you have title and possession. For declaration, prayer co, you have said defendants do not have any possession, and go, you are saying in co schedule they will not construct illegally. That means they are in possession. Where is your prayer for recovery of khas possession?
मतलब গ আর্জির ক তপশিলে সামিল খ তপশিলে লিখিত ভূমি হইতে 1 নম্বর বিবাদিনীর অবৈধ নির্মাণ কার্য অপসারণ পূর্বক
বেদখল করিয়া দিতে না পারেন,
আমরা বাদীকে খাস দখলের ডিগ্রি দিবার আজ্ঞা হোক।
and next বাদীকে গায়ের জোরে বেদখল করিয়া দিতে না পারেন। That is why I'm asking you. Contradictory prayers,
prayer number
mutually destructive. Go.
ঘ
Go.
1 নম্বর
Mutually destructive prayer.
that is further construction. They cannot make further construction.
বাদীকে গায়ের জোরে বেদখল করিয়া দিতে না পারেন
এবং আক্রমণ করে
বাদী দখলে কোনো বাধা সৃজন করিতে না পারেন।
মানে
So you are in possession in kha ka. Show me in which portion you are in possession, in which portion you are not in possession. Kindly come to prayer ka.
আজির ক তপশিলে সামিল খ তপশিলে লিখিত ভূমিতে বাদী ষষ্ঠ সাব্যস্ত করত বাদীকে
Declaration of title in ka and kha.
Declaration of title in respect of ক
and kha. Prayer kha.
আজির ক তপশিলে সামিল খ তপশিলে ভূমিতে 1 নম্বর মূল বিবাদী কোনোদিন কোনো বৈধ সত্ত্ব দখল না।
Yes, so you have sought for declaration that he has no title and possession in respect of kha.
No, I have a right in respect of q scheduled property.
Kha is a part of kha.
Yes, q is a part of q.
So prayer kha, you say that they do not have any possession. That is the declaration you seek, and you are seeking for recovery of possession. Contradictory prayers.
I prayed for.
That is why I am saying contradictory prayers. Prayer kha, you are saying they do not have any possession. Gha, you are saying recovery of khas possession.
I say খ তপশিলে
how have you valued your suit? How have you valued your suit? Rupees 100 or 49?
No.
58,000?
58,000 and
Yes.
19.
Yes. And where is the enclosed portion? How have you described in your plan? Where is the sketch map? Which portion?
Sketch map.
Entire kha schedule?
No. Kindly comes to the kha schedule.
Yes.
Kha schedule plots are the marked. Kindly comes to this map portion.
Yes.
The dag number.
That is the goli rasta. That is the goli rasta.
Dag number 6088 Badi. And 6084 Badi.
6088 and 6084 is of the plaintiff. Yes.
Badi.
Yes.
Badir বসবাসে দ্বিতল বাড়ি 6084.
Yes.
Now there is no regarding encroachment or making illegal construction. But in respect of 6088, the defendant plot is 6085 adjacent to my plot.
Yes.
Now
so they have encroached upon your property.
6088.
So that is the hash mark portion.
Hash mark portion.
Show me from the local inspection. You have sought for that. Which page?
Point number page 56. Point number 1.
Yes.
6088 দাগের 10 শতকের মধ্যে পূর্ব তরফে 2.1 শতক তৎসহ উক্ত 6084 দাগের লাগাও উত্তরে 6085 দাগের ভূমি মাই তদস্থিত পাকা গৃহাদি তত উত্তর দাগের নতুন কনস্ট্রাকশন সরজমিনে পরিদর্শন করিতে হইবে।
This is not matching with kha topshil.
Yes, all these plots are
2.5 decimals.
Yes, kindly comes to
2.5 decimals. Where is that?
Cost schedule kindly come. I am the owner in respect of 6084 in respect of 5 decimal. And in respect of 6088, out of 10 decimal, I am 2.5.
Yes.
Now, in that portion of that property, defendant making construction. I prayed for recovery of possession of that. Not from making any further construction.
Yes. So not for the purpose of the suit, for the purpose of the injunction application. Please come to your body of the application. Not for the purpose of ascertaining the encroachment. And what have you said? That মধ্যবর্তী দাগের দৈর্ঘ্য প্রস্থ পরিমাপ। So পশ্চিমে such and such সর্ব মধ্যবর্তী জায়গায় it's a dimension of the construction. So you have not sought for that encroached portions. Local investigation you have not sought for. The purpose is for obtaining police protection. How this local inspection will help in come to the aid in deciding the application for police help?
The order pass directed both the parties.
You have sought for that.
Whether
You have sought for that. That cannot be a ground for allowing local inspection.
Until unless this is ascertained, he
Not ascertained.
he is making construction
Yes.
in the
There are ways and means to prove that. For that, local inspection is not necessary, Mr. Bose.
The landed coordinate bench directed the landed code below to allow this application to ascertain this. Kindly see shall allow
By the order.
But petition is the plaintiff, my lord, suit for declaration, permanent injunction, my lord. And I am sought for the, my lord, declaration that the deed executed in favor of the defendant is also, my lord, inoperative, my lord. I filed an application under section 30, order 39, rule 112, my lord. The status quo order was given by the trial court, my lord. And there the learned trial court observed that as because without trial it is not possible to decide the Hebanama which I have challenged, my lord.
Where is the order of the trial court?
My lord, trial court, my lord, page 21, my lord.
Why have you not filed the certified copy of the trial court's judgment? It's not necessary.
I'm sorry. My lord, মানে দুই পক্ষ শুনে বর্তমান নথি পড়ে আদালত দেখতে পেলেন যে যেহেতু বর্তমান মোকদ্দমায় বাদী ও ক্ষমতাবসী বিরুদ্ধে নামিত দলিল চ্যালেঞ্জ করিয়াছেন, সেই কারণে যতক্ষণ না সেই দলিলখানি অত্র সুপ্রমাণ হয়েছে বা ভুয়া প্রমাণ হয়েছে ততক্ষণ পর্যন্ত বিবাদীগণের বিরুদ্ধে কোনরূপ নিষেধাজ্ঞা প্রদান করা উচিত হইবে না। So my lord, thereafter, my lord, the trial court has, my lord, passed an order of status quo. Against that, my lord, the defendant, my lord, filed an appeal, my lord. The appeal court had also, my lord, concurrent with the finding of the trial court, but my lord, he has set aside the order, my lord. My lord, my lord, this is my submission is that, my lord.
Give me a minute. Yes, the defendant is, defendant number one is claim, you are the plaintiff.
Yes, my lord.
Defendant number one is claiming title by virtue of a deed of 2005.
Yes, my lord.
And you are claiming by virtue of 2013.
My lord, 2005 deed, but my lord, it is
Different one.
yes, my lord. That
That you have to prove it's an earlier date.
my lord, status quo order, my lord.
No, no, no.
My lord, kindly consider this, my lord. Status quo is not, my lord.
Prima facie,
clear-
you have, prima facie, you have not
my lord,
proved your.
my lord, 2005 deed, my lord, but it is registered in 2016, my lord.
Yes, yes.
My lord,
Prove
and,
that.
and that is, my lord, kindly see the plain, my lord.
Once it is registered, it relates back to the date of execution.
That is true, my lord.
Section 47 of the Registration Act
That is true, my lord.
is clear on that.
But-
Once
but, my
it's
lord,
registered, it's related back.
My lord, they have changed the my lord, pages, my lord, kindly.
I'm expediting the suit. I'm expediting.
Status quo, my lord.
My lord, I am appearing for the petitioner in this case. Yesterday, this matter was taken up. I was asked to inquire about the lawyers there.
Yes.
The lawyers appearing for the lawyers appearing for the opposite party defendants there are named Debashish Chakraborty and Suparna Ganuri. And the lawyer appearing.
I cannot take up, sorry, since I'm not inclined to take up this matter on. Yes, call the next matter. Kunta, dispose of. Yes, next, call the next matter.
23. Item 23, Your Lordship, I am appearing on behalf of the petitioner. Your Lordship, I am led by Mr. Chatterjee. He is not currently available, Your Lordship. I have been asked.
Which Mr. Chatterjee?
Honorable Chatterjee.
Honorable Chatterjee was available in the morning. What is this matter?
Your Lordship, this is
My lord,
challenging
I am
an
appearing
order.
for the opposite party, my lord. My lord, I am also praying for some time, my lord.
Your Lordship, this is an application challenging an order allowing the defendant's application under Order 8 Rule 6A for filing their counterclaim. Lordship. Lordship will find.
Have you have been served with a copy?
Yes, sir.
Yes, my lord, I have served with the copy, but my lord, my clients are in out of station, my lord. I need some time for their instruction, my lord.
On the prayer of the learned advocates for the respective parties. Next matter.
My lord, kindly fix it after vacation, my lord.
I am appearing on behalf of the respondent, on behalf of the petitioner husband.
Yes.
Lordship, petitioners came before your lordship challenging the order dated 28th March 2025 passed by the learned additional district at Session Judge Second Court Sialda in which case number 6 of 222 under section 36 of the Special Marriage Act in connection of the match suit number 2 of the 22.
Yes.
The fact of the case, my lord, the petitioner filed a match suit. During pendency of the match suit, the respondent wife filed a maintenance case, and the landed.
What is your income? You are appearing for the opposite party.
2 lakh, more than 2 lakh. No. And that is no, I will pay 49. But my lord, kindly see.
Must come at 2 p.m. Please come at 2 p.m.
Continuing matter 24. Lordship, I am appearing on behalf of the petitioner husband.
Yes.
Lordship, the order dated 28 March 2025. I am challenging this order passed by the learned additional district session judge, second court Sialda.
Give me a minute.
Yes.
Yes.
Lordships, my humble submission before your Lordships. The respondent wife filed maintenance application in connection of the mat suit. Learned James directed to pay 8,000. Thereafter, she preferred an appeal.
Now 15,000.
15,000 passed by the Honorable High Court. Honorable High Court affirmed this order of learned additional chief learned chief judicial additional district and session judge. And only Lordships kindly see page 28.
Yes.
Have you Lordship got it? Coordinate bench, Honorable Coordinate Bench affirmed the order dated 31st May 2019, page 28.
Yes.
Affirmed the order that is 15,000 per month and with on only modification that the interim maintenance would be payable. Have you Lordship got it?
Yes, yes.
Payable from the date of the order passed by the Learned Division Court, from the date of the order.
Yes.
Then, my lord, now I am paying 20,000, 15,000 per month maintenance and interim maintenance, 5,000 the defect order, pursuant to the defect order, or for separate accommodation. Now I am paying 20,000 per month. My document is here. So, my lord, now my gross salary is 1,98,000. My tax, income tax already deducted. Thereafter, gross salary 190. My mother is suffering cancer. Lordship, kindly page 47. He's suffering cancer patient. Page 47.
Yes.
Lung cancer. page 47, P6 annexure. Left side, lung cancer for long 2 years. Then another document, doctor prescription and medical, that is lungs, right side, page 48, right lung, 4 biopsy and mole cell. Have you got it? Then most of the amount have been paid by my mother's treatment, and also her caretaker and also her caretaker and Aya. Then, my lord, so I pray before your lordships kindly to consider my case on sympathetically ground. And my lord, on the other hand, my land, the respondent who I filed an application under 36, under section 36 of the Special Man's Act, he is claiming 35,000, but in the said order,
5,000 only has been.
he never put the backup in respect of the 35,000 before this honorable court. Honorable court directed 5,000 and from the date of filing of this application.
Yes.
Third line.
Yes.
So my humble submission before your lordships to modify this line to date of filing this application instead of date of the order. Honorable High Court already passed the order. The date of the order, area maintenance will be paid from the date of the order. Honorable Coordinate Bench. So my humble submission before you lordships, from the date of filing of this application, kindly to modify.
That has been done. From the date of filing of this application, it has been done.
But my lord, date of the order.
From the date of the order.
That's my humble. Only
your prayer. Yes. Anything more?
Actually, I am suffering from cancer. My mother's cancer patient.
Please use the microphone. Please use the microphone. Yes.
My lord, my learned friend, my lord, made a clever attempt not to enclose any payment of the medicine, as because, my lord, the husband, father, mother, my lord, is a central government pensioner and got the cashless medical benefit. First point. And my lord, second, my lord, his salary is, my lord, August 2024, my lord, 1,98,000. And my lord, at this juncture, my lord, it is not less than, my lord, more than 2 lakh, at least. And my lord,
where is the finding of the learned trial judge with regard to the husband's income? Where is that?
My lord, that is, my lord, page 2, para 3, last sentence.
Page 2.
Page 2 of the impugned judgment.
It was all
1,98,000. Yes.
1,98,000. He's got salary.
August 24.
Salary.
August 24, my lord, that is.
He's got salary.
Yes.
Therefore, my lord, 5,000, only 5,000, my lord, enhance as because, my lord, the earlier order passed in the year 2019. And, my lord, today, my lord, we are on, my lord, 2025. My lord, that means, my lord, more than...
That is why he is saying it is to be from the date of the order. He says to be modified from the date of the order.
Actually, this is not my fault. This is the court proceeding.
This is, my lord, passed, my lord, in the proceeding of under section 24 of the Hindu Marriage Act. And, my lord, the application of the under section 24, my lord, filed by the, my lord, petitioner wife.
24 or 36?
36. 36 of the Special Marriage Act. So that, my lord, she is entitled to get the maintenance under section 36 of the Special Marriage Act on the date of filing.
All right.
And, my lord,
only
and, my lord, moreover, my lord, my husband, my lord, the petitioner, my lord, at least, my lord, 4 application, he has right. He has right. I am no, my lord, agitated that he has no right. He filed, my lord, one after another.
This application
Let it be
disposed of করে দিন। Yes, next. এবার যেগুলো ও জাজমেন্টটা দিয়ে দিন, জাজমেন্টটা।
My lord, there was a supplementary list, my lord.
আরেকটা কল করে দিন। Yes,
ওটা কিন্তু ডিসপোজ অফ করে দেবেন, ডিসপোজ অফ।
Item
Is it
number?
one?
Yes, Mr. Datto.
Yes, my lord. Item number 1 of the supplementary list, my lord, I had mentioned this matter. My lord, lordship will be having difficulty because, my lord, Honorable Justice Jyotirmoy Bhattacharya is the presiding member of the arbitral tribunal.
Supplementary list.
Lordship, CO number 101868. PO number 1868 of 2025.
Supplementary list করেছেন ওটা ডাকুন। ফাইলটা
It is the arbitral tribunal is presided over by Honorable Justice Jyotirmoy Bhattacharya.
ফাইলটা নেই।
Supplementary list, item number 1.
My lord, I appear for the petition, my lord. I'm challenging an order of the, my lord, Commercial Court Rajarat passed in a section 37 appeal arising out of an order under section 17 where, my lord, the tribunal has passed certain orders. My lord, difficulty would be, my lord, the constitution of the tribunal.
Inclined to take up this এটা একটা উপরে লিখে দিন। Call the other 2 PM matter.
My lord, maybe only
Yes,
sign, my lord, there.
yes, yes. এই এটাকে একটুখানি করিয়ে দিতে বলুন, তাহলে করে দেবো এটাকে। Yes, call the next matter.
Judgment দেবে না। 21, my lord, instrument, my lord, I am appealing from the defendant petitioner. Defendant respondent petitioner. Suit has been filed for declaration that the plaintiffs of the Shevite and they are entitled to carry on the functions and the business of the deity. On these grounds, my lord, can you turn to page 21 of the judgment passed by the London Trial Court, page 20.
Injunction has been allowed.
Allowed. Revert to the suit. One thing, my lord, page 20, last paragraph.
Yes.
The plaintiffs have not, my lord, got it.
The plaintiffs have not filed any
This is,
case ROR.
even LROR recorded in the name of the plaintiff as Shevite because they are claiming time on the basis of such record that executor of the trust deed such and such have not filed any document to show that they are Shevites of the suit property, have power to execute the said deed, and the plaintiffs have not filed the deed of gift being such and such.
What is the injunction passed?
Now, my lord, can you consider it has held the suit is they are not entitled. Now, my lord, in this backdrop, my lord, can you consider the injunction not page? Yes.
The suit was dismissed.
Suit dismissed.
So in the title appeal, this injunction was passed.
Yes. Mark it on internal page 4 of the appeals court judgment. Findings of the court. My lord, got it.
This is ex parte or contested?
Ex parte injunction. Not only that, you also allow with police help. No, ex parte.
Contested.
Contested.
Say so because I am seeing interim injunction is hereby made absolute. What was the interim injunction,
Yes.
Mr. Rai?
Yes, that was past expertise, my lord.
But you have not challenged that. This has been made.
Consider if I participate in I have two courses are open. One to participate by filing objection.
It's no dispute on that. But what can be done now, Mr.
Now,
Rai?
my lord, consider what the injunction has it passed. The respondent filed the writ of stating that the table was built at the money provided by the villagers.
Contention of the appellants is that they cannot perform the. Oh no, sorry. What is the injunction? Prayer of injunction is allowed.
The order interim
What was the interim? That was made absolute. What was the interim?
Yes, ma'am. Can I turn to page 58? এটা একই ব্রেক টু ক্যারেক্টার interim order 50 page 50 page 50 my lord.
No, page 50 or 63.
No, page 50. Can you turn to page 48?
No, what is page 61?
Page 61. My lord is looking page.
Oh, 61 is also the final one.
It's same.
What are you doing? Xerox copy, certified copy. I found a Xerox copy. I thought that this is an interim.
Page 48, an interim order.
You have been restrained from disturbing the appellants in performing their acts as Shemaites.
Yes.
DT, Nitya Seva Puja.
Everything.
And the annual puja till. When is the annual puja?
On 29th. 29th. Annual puja is the day.
Sir, what can be done? Injunction, if it is granted without state, and the Nitya Seva Puja will be affected. You can serve, I can.
In other way, my lord. Suit dismissed prior facie, my lord. I am on the basis on which basis. Then what is the meaning of dismissal of the suit?
Mr. Rai, I appreciate that, but this order is continuing from 22nd of May 2024. So kindly appreciate this. What is the urgency that it is to be vacated without hearing the other side? Kindly consider this. An order of injunction continuing for more than one or just 1 year. Today we are on 21st. It was passed on 22nd of May 2024. 1 year you are suffering an injunction. I am directing you to serve.
Once one can turn to final order. Once one can turn to the final order. Final order, I am not disturbing. What is there? Well, let them.
Final order, this order has been made absolute.
No.
Police help.
Now petition such and such file were taken up for passing orders. After the final orders, 151.
150. Yes, after the order, police help.
Now one can consider. Now the condition of the appellant is that they cannot perform the Nitya Puja or the deity because the officer in charge locked up the temple door and the key is lying with the police. It is further contained that the respondents forcibly installed the CCTV cameras in the temple. It is further submitted that the respondents are taking away the offerings given to the deity. So even assuming, my lord,
is directed to hand over the key of the temple.
Well, where I put this question to myself, where is the findings to that effect? If he is in position.
But Mr. Rai, they were directed to do the Nitya Seva Puja.
So
Seva Puja is to be done.
That is why, my lord,
that purpose
they have done for 1 year. I put this question in other way, my lord.
No,
there is no allegation against me.
The only thing is that, Mr. Rai, the Shiva Puja will be stalled. That is the difficulty. And you are coming at a point of time when there is no time to serve and then come. I can do one thing. I am directing to serve. I am keeping it in the vacation bench. Posting it in the vacation.
অ্যানুয়াল পূজা কবে আছে? 29 মে। এর মধ্যে কি করে হবে? হ্যাঁ? তারপরে রাখতে বলি তাহলে সাবস্ক্রিপশন তাহলে রিওপেনিং করতে হবে তাহলে তো only one thing, my lord, I'm not on that. So much Nitya Puja and other things. We are the villagers because for the public deity.
So allowed to participate in the, because now we have been restricted from.
Not know what is the allegation without hearing. That is the, because Mr. Rai, this order of injunction is continuing for more than a year. You have also not challenged. You are right, absolutely right, that you are justified in contesting that. But you are suffering for 1 year. So please, sir, I'm directing this to appear.
Only one thing, my lord, that is the only, I am, some of the other things.
Could have approached.
That is only, that is the.
What the other alternative which I have given?
My lord. Alternative is only, so some provisions, so far we can approach that, we can also participate in the process.
So I'm appointing you as a receiver. I'm appointing you as a special officer. So under your supervision.
Only one already been put out for me.
No, this is Nitya Seva Puja, Mr. Rai. You have a duty.
So I'm they let them perform the Nitya Seva Puja. What they are doing there, till down, taking position from the police. I'm not standing in the way. But what?
By the order
Participation.
impugned. Report has been called for to ascertain as to whether any lock is there. Maybe there is no lock.
No,
Last paragraph.
he is the direct handover.
Yes.
That is why one of the.
That is their allegation. Police to be directed.
No.
Report has been called for to
Police has
ascertain.
not the keys.
Yes, that is their prayer.
No.
And the report.
No, no, my lord. Subject to action, my lord. May I once, my lord? This was not the response. Yes, after hearing both sides, I am of the opinion that since the right of performing Seva Puja and to manage.
Yes, yes.
Page 6 at the top, my lord.
Yes, yes.
That is not finally decided.
Yes.
It would not be proper to instruct the respondents to remove CCTV camera.
Regard to the removal of the CCTV camera.
Moreover, instruction.
Next paragraph with respect to the contention that a lock and key
is put in the main entrance of the
officer in charge
of the
that the report must be called for before passing any orders.
From the
is directed to submit a report. No order has been passed. What are you saying, Mr.? I've seen that.
Whether the lock is put by the
Yes, so
by the PS.
Yes, so to ascertain a report has been called for.
23/4
So what happened?
ঠিক আছে, তারপরে কি হলো?
You are not vigilant, Mr. Rai. I'm not saying about you, your client. Report was called for 23rd of April.
After vacation. And
12th.
12th after vacation.
Because you don't want it earlier.
No. It is better to die
And judgment.
than
Judgment.
to be injured.
For judgment.
Better to die instead of getting injured.
CO number 1599 of 2025 and CO 1600 of 2025 stands dismissed.
This is against an order rejecting my application under section 47 of the Civil Procedure Code. What has happened, my lords? The opposite party has plaintiff, my lord.
What is the ground in 47?
47 on ground, my lord.
Inexecutable.
Yes, my lord.
Degree on what ground?
My lord, what ground, my lord? That is why, my lord, I am coming, my lord.
Property cannot be identified.
Property cannot be identified. My lord, High Court has passed an order.
Usual ground in 47.
No, my lord, that is
That's
not
the
the only
usual grounds in 47. Property cannot be identified.
No, my lord, that is not the. I am to place certain facts before your lordship, my lord. That is fine. Your lordship kindly come. My lord, suit has been decreed only on the ground of rebuilding. Well, other grounds have been waived, my lord.
Yes.
Yes.
That is also a valid ground for eviction.
No, my lord, I am
Building
not
and
saying that.
rebuilding is also one of the grounds available under
The
section
promoter has
6(1).
filed the suit. Well, that is not the case here, my lord, because my lord, that has been
Decree cannot be reopened here. What is the ground under section 47?
I am not paying before your lordship for reopening the degree, my lord.
Yes.
My lord, I am to place these judgments of the lower appellate or lower.
Why? What for?
That is why, my lord.
No. 47 you cannot enlarge the scope. This with regard to the execution,
my lord.
discharge and satisfaction.
Interpretation, my lord. Only interpretation, my lord. Otherwise, my lord, your lordship only short interpretation. Your lordship kindly see.
Short, long, no interpretation. Executing court cannot go behind the decree.
No, my lord, that is why my case, my lord.
Yes.
That is why my case. Your lordship kindly see the order passed by the learned appellate court. My lord, only one thing, your lordship kindly see.
Then I'm posting it after the vacation. If you want to place.
11 is the date fixed. My lord, your lordship kindly.
47, show me within the scope. I will not go to the decree of the trial court, appellate court.
My lord, your lordship kindly see. Then High Court's order, my lord, I am placing before your lordship.
Sir, I cannot reopen the decree. Please show me why the decree is not executable.
My lord, the executing court has go beyond the order passed by the High Court.
Show me that.
Yes, my lord.
Show me that.
Yes, my lord. Before that, my lord, I am to place the order passed by the land.
Show me where it has gone beyond the scope. Show me from the order impugned.
My lord, from the order impugned, he already discussed. My lord, only one thing, your lordship kindly see the land appellate court.
Where is the section 47 application? Show me that.
Section 47 application, my lord, is at page. My lord, section 47 application, my lord, is at page. My lord, annexure D, page 42, my lord.
42.
Yes, my lord. My lord, page 46, para 14, my lord.
Para 14, yes.
My lord, from para 12, we also kindly see para 12, my lord. The degree holder have not yet mentioned the judgment and order passed by the Honorable High Court, which says
yes, why the decree is nullity?
My lord,
why the decree is nullity?
My lord, decree is nullity is one thing, my lord, but
no, that is your ground. Why? I'm asking you, why the decree is nullity?
My lord, because my lord, the High Court, Honorable High Court has said the last portion of the degree passed by the learned lower appellate court is contrary to law, and that portion has been set aside. And my lord, on the basis of that, my lord, execution case has been filed.
Show me which portion has been set aside.
Yes, my lord, that is why I'm saying. High Court's order, name, my lord, I'm coming before the High Court's order. My lord, page 31, your lordship kindly come to the lower appellate court order, last portion. Which portion has been set aside?
Page 31, yes.
Page 31, bottom. The instant appeal being number such and such be and the same is accordingly disposed upon contest without cost. Next, my lord, the impugned judgment and decree passed by the learned civil judge Howrah in connection with the title suit number such and such hereby affirmed, subject to modification, that both the parties will execute an agreement in writing to the effect that the appellant defendant will vacate the suit premises and arrange his own accommodation within 1 month from the date of passing of this order, and the plaintiff respondent will reinstate him within 3 months from the date of vacating the suit room by the defendant after raising new construction thereon, subject to payment of agreed between the parties as per the market value. But this portion of the order has been set aside by the High Court. And next, page 40, your lordship, that portion of the order has been set aside by the High Court. And now, my lord, without modifying the execution application, my lord, they proceed with the execution and my lord, it has been issued. Well, that is a missed case, my lord, or section 47, my lord, degree holder neither appeared, not filed any opposition, my lord. That was hard ex parte and the ex parte order, ex parte, it was dismissed, my lord.
Yes, where is the tabular statement?
Well, the tabular statement is not with me right now, my lord. Your lordship, they did not serve, my lord, the tabular statement. My lord, on the basis, my lord, they filed the execution application when the appeal was pending before the High Court.
Show me that point in 47 which you have taken.
My lord. Page 42.
Yes. So now, according to you, after modification by the Honorable High Court,
Yes,
what is the decree now?
My lord, they cannot, my lord, so far as the agreement portion is concerned.
Yes, agreement has been set aside.
Agreement, my lord, that has been incorporated in the execution of your lordship.
All right, so you have to vacate first. You have to vacate. That has not been set aside.
My lord, your lordship.
Mr. Gupta, whether your direction to vacate has been set aside.
No, my lord, I am not. My lord, your lordship, last
vacate.
portion of the order, my lord.
Yes, yes, that will come. That is reinstatement.
In the execution case, my lord, they have to incorporate the order passed by the, at least by filing a affidavit.
Yes.
That this is the order passed by the Honorable High Court. But that has not been stated. I have specifically stated in my miscase.
Show me this point was raised by you before the executing court.
It is pertinent to mention the schedule of the suit property will not even mention. The degree holder did not mention even the judgment and order passed by the Honorable High Court. We set aside the last portion of the judgment and order passed by the appellate court. The execution.
Okay, which page you are placing of the impugned order?
My lord.
Which place of the impugned order you are placing?
No, my lord, I'm placing.
No, I'm asking you that you have placed this point in the executing court. Show me that.
That is page 46, my lord. This is the point.
46 is your application.
Yes, my lord.
Show me from the impugned order that you have raised this point.
My lord, I'm showing you, lordship. My lord, in the case in hand, the order of the Honorable High Court, Calcutta, clearly reflects that the order did not find any error of the judgment of the learned. It is also reflects the Honorable High Court's view that the degree of the first appellate court is perfect, 7 except the last portion which has been directed to sale purchase of the tender portion. That part only set aside by the Honorable High Court, rest of the judgment and degree first bed. Accordingly, it is clear that the judgment and degree of the trial court and the first appellate court stands on. Now the judgment debtor himself preferred a second appeal. It is clear that he has knowledge. My lord,
My lord, learned advocate for the judgment that are contended.
Which page? Which page?
My lord, it is page 7. The learned
Page 7.
Page 7 of the order, my lord.
Yes, yes.
The
Page
learned
7.
advocate for the first, second, third, fourth paragraph.
Yes.
In a schedule of the plaintiff, the
Yes.
beholder did not mention the actual area of the tenanted portion, whereas the learned trial court specifically directed size of the tenant cannot be reduced and portion. I fail to consider in the execution proceeding, my lord.
So this is one of the point raised that
point
exact
has
area was not mentioned.
My lord, that is true, my lord. That has also been raised. Otherwise, my lord, this portion, this order has been, they would not have been passed, my lord.
Yes, yes. Yes. And another point is decreased nullity. That you have raised.
Nullity in the Isbachas, it is not executable, my lord.
Yes.
All questions, my lord, regarding execution satisfaction of the degree.
According to you, what is the decree which is executable? It has gone.
Yes, my lord.
No degree remains.
No, my lord, I am not on that.
I'm asking you.
My lord, they are to.
I'm asking you, what is the executable decree now, according to you?
My lord, they are to delete the portion of the agreement.
I'm asking you, what is the executable decree now, after the order of the division bench? What is the executable decree now?
My lord, executable decree, my lord. Question.
There is no executable decree.
Question of repair, my lord. Question of repair is there, my lord. Only question of repairing.
Repairing, nothing more than that.
No, my lord. No. Only question of repairing. Because, my lord,
you're vacating the premises is not there.
My lord, your loss.
You're vacating the premises.
That was the order of the court, my lord. That is the order of the first trial court and also the first appellate court.
That has not been disturbed by the by the division bench.
By the division
vacating.
bench.
So you vacate. Otherwise, how it will be repaired?
They will not reinstate, my lord. After
that is a different thing altogether. For that, you have other remedies. Please vacate for repairing.
My lord, your loss you can take up after vacation. After vacation, my lord. 1 week after vacation. My lord.
After some. After 2 PM nahi hoega cha? Yes, call again.
25.
Lamp for the petition.
Yes.
But the petitioner is the husband of the opposite party. There is a divorce suit pending. In the divorce suit, my lord, the opposite party wife. My lord,
what is the order?
My lord, order is, my lord, 10,000.
Alimony.
Alimony. Now, my lord, kindly sees I am a gym trainer, and that is admitted by my wife also. I used to get 8,000 per month, 9,000 per month, and my salary slip has been given by my employer also. And my lord, kindly sees the order, learned how the learned judge dealt with this part, and my lord, passed an order. My lord, she also earns rupees 8,000 in a cosmetic shop from the date of order. My lord. From the date of.
No, she is earning from where?
No, cosmetic shop, my lord. But my lord, we falls under.
Just give me a minute. Yes, what is your income?
My lord, 9,000.
And what is your expenses?
9,000. Almost 9,000, my lord. That is the case, my lord. And how I will give, my lord, 10,000. And learned judge disbelieved that part only. And without having any basis, my lord, my status has been assumed by the learned judge. My lord, kindly sees considering the facts and circumstances of the case and status of the parties. Now, how my status has been judged. We used to fall under BPL category. My lord, I have
produced your electricity bill.
My lord, 100 rupees. 100 rupees.
Have you annexed any document that you are paying 100 rupees as electricity bill? Have you annexed any document?
My lord, he used to.
I am asking you.
No, my lord, he used to.
Yes, I appreciate.
100 live in his gym, my lord. His employer allowed him to stay in his gym.
I am asking you, you are incurring 100 rupees as electricity charges. Do you have any document in your support?
I used to give 100 rupees as electricity to my gym owner, my lord.
Where is the document?
There is no such document, my lord. 100 rupees I used to give for electricity. I used to stay in his one room.
Difficult to believe.
We are in.
It's difficult to believe your expenses is 9,000 and your earning is 9,000.
My lord, mother is ill. We are BPL category, my lord. I have
Very
got the
difficult to
certificate.
believe.
So, my lord, kindly give some relaxation, my lord. Kindly give some relaxation. My lord, I will go make on payment of 5,000 for the time being, my lord, and let it be, my lord, come as contested application, my lord. Let them come. Let them contradict. My lord, she admitted that I am a gym trainer. My lord, kindly see also, my lord. She also admitted that I am a gym trainer. But she said I used to get 40,000 as a gym trainer. My lord, this is not.
Gym trainer has fabulous income nowadays.
Maximum payment is.
Everything is very, everyone is very conscious.
My lord, in a gym, there are number of trainers. My lord, your lordship knows, my lord. And maximum payment is 10,000, my lord. Any gym, my lord. Even in gold gym also, my lord. There are number of gym trainers in the society. My lord, kindly appreciate.
So, Lordship. Lordship, I have prayed, challenge the order, judgment of a miscellaneous appeal, Lordship.
Injunction.
Lordship, shoot for declaration and injunction.
It has been remanded to the trial judge for fresh reconsideration.
Lordship.
I think it's better.
Kindly listen, Lordship. There is an order of under section 142 of CRPC, Lordship. There it is there that there is a pathway. But the learned appellate court.
Where is the order passed by the trial judge?
Lordship, Annexure D, 68, Lordship.
68.
It was only status quo, Lordship.
Yes, where is your plaint?
Annexure T, A, Lordship, page number 13. Okay. Okay. বাবা তো কি ওর বান তার ছেলেকে ফোন করে জিজ্ঞেস করতে পারছে না কি লিখেছিস কি ভাই দুবাই ড্যাডি।
Yes, it's a joint property. How this suit is maintainable?
So, Lordship, this is they are possessing the suit property.
Yes. So you are facing difficulty in joint possession of the property.
No, Lordship. Actually, they
It shows from the plaint. It shows. Why would not paid for partition?
Lordship. Actually, they are destroying the pathway, Lordship. That is the main difficulty. That is why we have filed one application under section 144(2) before the learned SDM.
Proceed with
Sir,
that.
Lordship, kindly.
To serve, let them come.
They are destroy the pathway, Lordship.
By the order.
The government officials have confirmed there is a
Considering the fact that the yes, yes. On record. On record. Yes. Where is Mr. Devjit Mukherjee?
He is in court number 35, my lord.
Yes. You are appearing. Yes.
Lords, in this matter, Ms.
It's
Mousumi
taking
Hall
for
is
5 minutes Passover, my lord. Both of us.
Lord, a Passover may be granted. Or, my lords, may kindly makes it not today, my lord, tomorrow.
It's urgent for us, my lord.
Passover next.
28.
Yes.
20. It is an application for expeditious disposal of the matrimonial fruit, my lord, pending before the learned second fast track court at Barasat, my lord. The suit for under section 12 of Hindu Marriage Act has been filed.
This application under article. You are for the.
I am for the
May I please, Your Lordship? My Lord, I am assailing the order passed by the Honorable Chairperson TRAT, my Lord, in connection with an appeal passed by the petitioner. My Lord, the impugned order is 25th April 2025. Your Lordship.
Section 14, what is the ground of your challenge?
My Lord, the ground is, my Lord, the bank. My Lord, Your Lordship knows an affidavit has to be passed and the district magistrate declared to be passed an order in consonance with the 9 clauses as appended in section 14(1). My Lord, the bank has
41.
14(1).
14(1).
Sorry, sorry. The bank, my Lord, has fraudulently, my Lord, has suppressed the fact that the petitioner has made substantial payment. So, my Lord, the clause 14(1), my Lord, the first clause, my Lord, may I just read out the relevant place, the section 1, my Lord, about the extent of the dues. Well, that has not been mentioned. And the Honorable Appeal Court on the one breath is saying that the appeal has become infructuous. Your Lordship, kindly see the observation. But on the other hand, proceed to dispose of the appeal on merit. My Lord, when, my Lord, the particularly, my Lord, certain point has been canvassed, my Lord, in the put of application, the appeal court has not made any endeavor. My Lord, only certain judgments passed by the Honorable Apex Court.
Where is the order of the award of the Lok Adalat?
Yes, my Lord. That will appear, my Lord.
Have you complied with that award?
Yes, but what has happened, my Lord? There is
Not what has happened, yes or no, complied, non-complied?
partly complied.
Yes.
Partly complied.
Part compliance is nothing.
No, I am not on that.
Yes, yes.
My Lord, so for the that is not, my Lord, my principal point. My point is, my Lord, the section 14(1), my Lord, the bank, the affidavit. My Lord, my grievance was I have made substantial payment, but it is under the
substantial payment you have not made. Lok Adalat award you have not complied.
That is on a different footing, my Lord.
Yes.
My Lord, because, my Lord, the 13(2) and 13(4), my Lord, that ought not to have been, my Lord, the account ought not to have been branded as NPA. Since, my Lord, this is under the Prime Minister, my Lord, the relief Prime Minister Employment Generated Fund, my Lord. There, my Lord, this government is the guarantor. And, my Lord, substantial payment made by the government. My Lord, I have got the scheme. But I have taken this point. Neither, my Lord, the learned presiding officer nor the appeal court has made any endeavor to deal with that point. If that point has been dealt with, my Lord, this judgment ought not to have been appeared. Because, my Lord, there is also in the award itself, my Lord, there is a delayed provision. There is a provision for making, my Lord, delayed payment of interest if there is a failure on the part of the petitioner to deposit within the 90 days.
Surface একটা দিন তো।
See, my Lord, section 14(1).
Surface Act, arbitration.
B, my Lord, A. My Lord, can you see?
14.
1. B1. That is my specific case. My Lord, this declaration of the account is NPA is bad.
Where is the affidavit?
Yes. My Lord, kindly come to the supplementary affidavit, my Lord. Well, that I have annexed. Annexure B. Yes, annexure B of the, my Lord, my revisional application. Annexure P2. B key na P. Your Lordship, that will appear from. Yes.
Page.
Yes, my Lord, page I am referring, my Lord. The page, it starts from page 123.
Yes. Show me that clause in the affidavit. Where is that?
Your Lordship wants to see the affidavit filed by the bank.
Yes, you are saying that has not been stated.
Annexure B মধ্যে এটা লাগানো আছে।
Well, this is part of the annexure B. Page 65, 68. Well, this is the affidavit filed by the bank before the district magistrate.
Yes.
Yes. Kindly come to page 68 once.
Yes.
Now your Lordship will find page 6. Turn to the next page, page 69. Well, there is no disclosure. So far, my Lord, on the date, whether they have received any payment or not, regarding, my Lord, the 8 lakh they have received under this scheme. They say there is a due, but nowhere, my Lord, there has been. It is, my Lord, specific case. It is also their admission that they have accepted that payment under the said scheme. So, my Lord, therefore, if your Lordship now come to the relevant section, my Lord, that the rule 14(1)B. Yeah, yes. Your Lordship, kindly come to the 14(1)B, my Lord, the 9 clauses, the aggregate amount. My Lord, that has not been mentioned. So the affidavit is also, my Lord, it suffers from, my Lord, patent illegality. There is no date. As of date, on that date, on the date of filing application, there is no due. They have not mentioned that they have received this amount. There's a clear fraud perpetrated by the bank. And my lord, the DM has not made any endeavor to, my lord, to ascertain when particularly when 9 clause, my lord, couch responsibility upon the district magistrate, my lord, to see the veracity of the affidavit. The courts, both the tribunal proceeded on the premise that since, my lord, it is a quasi-judicial authority, he has got no obligation to see whether, my lord, any dues is payable or not. My lord, then it has become a post office. Then the district magistrate, my lord, I have got no right of audience.
Show me the right of the borrower to challenge an order under section 14.
Well,
What is the scope? Show me.
Yes, madam. But there I will produce, at least there are gallant 19 to 20 judgments where, my lord, the veracity of the order passed by the district magistrate can be challenged before, not only under Article 226, also by filing surfacing. But I have taken out.
Come after vacation.
But in the meantime.
In the meantime, nothing.
Only one thing, my lord. The hearing of the surfacing application has been fixed.
Yes,
But I am also praying for restoration of possession. My lord, kindly fix the date.
You are paying for restoration of possession.
Because, but if the order goes, my lord, I will also, my lord, get back the property.
Yes.
But I am ready to pay the money.
Pay the money, approach the bank.
I have already approached.
Pay the bank money. Bank will hand over
the bank. But the question is, the quantum. If the quantum is disputed.
Come after the vacation. Please, this matter.
I'm also covered by your lordship one order, my lord.
Before my lord rises, my lord, item number 43 of today's list, my lord, was heard, my lord, at length yesterday. My lord, Mr. Abhrotosh Majumdar, Mr. Shoptangshu Basu, my lord, were leading me. Mr. Shobhoshachi Chaudhary was on the other side. Made me, my lord, fairly at the top tomorrow. My lord, do you suffering?
Let me see some 43.
43 of today's list.
43 টাও mark করে রাখুন.
44 and 160.
লিখে দিচ্ছি।
That matter.
Grateful to you.
Mr. Doctor had appeared your lordship one.
40
and item 163. 44 is their matter.
And 160.
163.
Yeah, 44. Please.
Mr. Chaudhary, second two.
Any.
Call the list.
Number 1.
Item number 1, I am for the petitioner.
Yes.
Evidence service.
Yes. Yes.
Evidence service, we can put the record. And here there is a supplementary affidavit filed. দুটো করে দিন।
Who is the alleged contemner?
শ্রীমতী রেজিনা বেগম সর্দার।
The Pradhan.
Yeah, only one soul.
The Pradhan.
Pradhan.
What was the direction?
just give me. Direction was to consider and dispose of the representation petitioner within 4 weeks from the date of passing of the said order. The respondent were kind of wrongfully and illegally filed and neglected to act in terms of the said order. Page number, order dated 27th of April 2021, page 25.
27th of page 25, yes.
Page 25. This is the order passed in the MAT 322/2021. Kindly see the page 28, the last para. Since the principal allegation of the appellants herein before the writ court was illegal construction made by the private respondent without obtaining sanction plan, the honorable single bench, in our view, was justified in directing the representation to be considered and disposed of by the concerned Gram Panchayat. The impugned order thus calls for interference by this court. We, however, extend the period fixed by this honorable single bench for consideration and disposal of the representation by a period of 4 weeks from the date of passing of this order, since a substantial period of the time allowed by the honorable single bench has expired in the meantime on account of pendency of the instant appeal. The representation has not been considered. The illegal constructions are still going on. Kindly seize the affidavit of supplementary affidavit which I filed today. Supplementary affidavit, page 2, para 2. Page 2, para 2. I state and submit that during pendency of CPANS 912 of 2021, the private respondents in MAT 322/2021, in collusion and conspiracy with the alleged contender, Srimati Rajina Begum Sardar, together with her men, agents, and associates, constructed illegal construction, Paka structures, building construction on the side parts of the pond at RS Dag number 973, LR Dag number 953, RS Khatia number 1153, LR Khatia number 495, 1022, 14368, 12 up to 14387, District Howrah, Block Donjur, Moza, Bakra, PIN 711403. The aforesaid illegal criminal activities by the private respondent in MAT 320/2021 in collusion conspiracy with the alleged contender Srimati Rajina Begum Sardar, together with her main agents and associates, resulted in the death, extermination of organisms, soil, animals, and
pursuant the next matter.
My lord, item number 2, my lord. My lord, I appear for the my lord review petitioner. There was a delay condonation application. Lordships were pleased to my lord issue directions because delay was more than 800 days.
Oh, this was that matter which I was hearing.
Sir, I
Justice Tandon.
Justice Banerjee. Justice Shonji Banerjee.
Yes.
My lord, but today, my lord, I have to seek, my lord, an extension of time to file my reply affidavit to the section 5. Reason being, my lord, they have affirmed it on 15th of January, served it day before yesterday.
I have to use an affidavit and my lord come back. I can come back on 18 June since lordships would be sitting, my lord.
So this is the review.
Review.
What order? What was the order?
My lord, kindly takes the memorandum of review.
Page, my lord, 26, my lord.
Writ petition was dismissed on the ground of, my lord, disputed questions. Appellate court, my lord, also, my lord, affirmed that order did not interfere. My lord, the issue was with regard to, my lord, an illegal, my lord, sarai, my lord, which was being run by the, my lord, respondent number 7. And my lord, that we had, my lord, there was a prior suit instituted only on that ground, my lord. The writ court and the appellate court did not, my lord, interfere. But in the review, my lord, we will try to convince your lordship to hold otherwise because of, my lord, the documents which we have appended to the, my lord, application now. And they were on record, my lord, when we, my lord, moved the, my lord, appeal. Kindly gives me a short
And what is the period of delay, Mr. Datta?
My lord, I have seen that. But if it is, my lord, otherwise, I will not argue on delay. When I, my lord, come with my reply, I will try and convince you on the merit first. If lordship feels no merit, dismisses my review.
So you want extension of time to file your reply?
I received it day before yesterday.
I am appealing for the 1 to 5, lordship. I am extended time for final reply, my lord. I am a state respondent, my lord.
Oh, you
1
are
to
for
5, my
the state
lord.
respondent.
State respondent.
Mr. Datta, who has filed the opposition?
The opposition has been respondent number 7. Who is the, my lord, contesting respondent, private respondent?
Now they also want an extension of time to file opposition.
They really won't oppose this, my lord. It's though I was, my lord, seeking orders on the authority to, my lord, close the sarai.
For this state
respondent 1 to 5.
State also did not contest in the main proceeding.
Really, my lord, the municipal corporation or, my lord, the police
Corporation has filed.
Here they have not.
You don't want to file.
Because
I am willing to file with their file.
My lord, it's really respondent number 7, my lord, who has any say here.
So, Dato, since you also want an extension, so how soon can you file?
After 1 week after vacation, 2 weeks.
The learned advocate. Who has refused to accept? Respondent number 2. He will give opposition to the petitioner.
I have got it. I have got it.
Mr. Datta, take it back. You did not serve upon the others. Keep it in your chamber. This building is sinking. Call the list. Oh. Awesome. সার্ভার করি একটু
27.
আর্জেন্সি আছে বলছে তো। Yes, call the list.
Floor matter 27.
Yes.
But I found yesterday two judgments.
Mr. Mukherjee, other side is not here. When they were there, you were not there.
I'm sorry, but I got a matter for justice.
Busy councils will have many matters.
A government matter, that is.
Yes.
Down, I was
Yes. So where is the other side?
that point up, she also prays for Passover. She is. May I just place my lord once, although there is no.
In the absence, they were there. Passover. Yes. Call the next matter. আমার লিস্ট কোথায় গেল? Yes.
সেখানে ওটা এসছে 30.
Yes, Mr. Ghosh.
Overt proceedings, my lord.
Yes.
I am the propounder, my lord.
Yes.
File exhibition chief, artistic witness already examined, my lord. Kindly see from the order sheet the
What do you want?
Lord, specified period, my lord, overt proceedings.
Expeditious hearing.
Yes.
This application under article. Yes.
Defendant is the petitioner before your lordship. My lord.
Yes.
The application for recovery of khas possession, eviction of licensee, my lord. The defendant petitioner filed two applications, one for repairing and one for local inspection. The local local inspection rejected. And my lord, not only
What
local
is the stage of the suit? You are a licensee. Will you incur expenses for repairing?
Yes, my lord.
Or you will wait till the
No, my lord. I want to incur not only
to incur expenses for
yes, my lord,
repairing,
but not only that, my lord.
for eviction of a licensee.
License. But kindly come to the order, my lord. The last line, last second paragraph, my lord. He
What
also
is your application for repairing?
repairing application, my lord. Kindly page 41, my lord.
Both the applications have been rejected.
No, the hearing was fixed for only for the advocate for the local inspection, order 39 rule 7. But in the instant application, he also disposed of the repairing application, my lord.
By the order impugned.
Wait, my lord. May I
Stay of what?
stay for the proceeding? Otherwise,
This repairing application is related to the main proceedings of the suit.
it
You are
was
trying to delay the suit. Then I am rejecting it.
grateful.
Yes. Yes, next. দুপক্ষের উকিল আছে?
87.
No, Mr. Mukherjee was trying to move this when you were absent. When your junior was there, he took a passover. And when you were not there, he moved that citing the emergency. Yes, Mr. Mukherjee.
I have a sanctioned building plan G+2. Admittedly, there is a mezzanine floor, one Thakur ghar, and one toilet has been repaired. Now, I filed an application in 2002
For
2022
for
acceptance or retention charges. That is pending before them. Now, what happened? A private party.
Any complaint has been made? Who is the private party?
My private party, if you see,
You have made him a party.
Yes.
Private respondents.
Private respondents. But they are not residing there. They are residing in complete different district. A suit has been, a proceeding has been initiated.
That does not entitle you to make an unauthorized construction, Mr. Mukherjee.
Absolutely. I'm not on that. That's Devangshi Bosak's judgment. Now, that's Bosak's judgment I lost up to division bench, Supreme Court also. Now, be that as it may, what happened, they lodged a complaint. Now, they came up before this court. Now, before Justice Chand.
No, thereafter, an order of demolition has been passed.
Order of demolition.
So according to you, without considering your application for regularization,
I filed a suit, your lordship knows now 218(3), my lord. It is a West Bengal municipal. I filed an application.
I'll assist him because he has not taken new provision has come. My lord,
I think one notification in that matter.
No.
Yes.
Rules
also have been framed. Subsequently, after that notification.
Yes. But before that,
that is why I was telling Mr. Mukherjee
that has been kindly see before the municipal.
Now, as per the rules, can it be regularized?
Yes.
If he said the small portion, so my lord, then my lord, can you see?
This can be.
Second proviso
31.
নতুন বই এসেছে
এটা বলা আছে ওখানে দেখো
এই বইটা আনিয়ে নিন তো।
My lord, this is recently
এটা আনিয়ে
এটা
নিন।
বলা আছে
32 sub second proviso.
ডেমোলিশন অর্ডার এটা আমরা আর্গুমেন্ট করেছি ডেমোলিশন অর্ডার পেজটা বলবো
Fiction.
অমলেশদা কাকা এত অসুবিধা নেই
Yes, this is almost identical to the matter you moved before the.
This one, then this notification.
Then this,
No,
yes, this is the subsequent, that is why.
No, this has been stated, my lord. Kindly see before the.
Yes.
My lord,
What
will
is
you
it?
pay me my fees? He should pay my fees.
That's between.
But that has been handed over to your lordship, my lord. Which my
My lord,
learned friend, senior friend is handing over. I have handed over to your lordship.
The
last
rules,
submission.
these are rules prescribed now, and
Rules দিয়েছি, my lord. My lord, kindly see, my lord, once.
This is the rules of, what is the date?
Same date.
22nd of July.
yes.
This is December, Mr. Mukherjee. Please see this. I was telling that there is a subsequent notification. You are saying no. I've dealt with this
No, I said that-
notification. I've passed an order. You are saying no, there
I
is
got the
nothing.
order.
Sir, your lordship refer Mr. Probal Mukherjee.
Mr. Probal Mukherjee
Yes, I-
appeared for the petitioner. Mr. Rai appeared for the.
প্রবালদা বললো কোনটা খেয়াল নেই
Mr. Rai appeared for the Siliguri Municipal Corporation.
Then when I seen that rules, no matter the rules are prescribed now.
So this is subsequent to this. So now proviso.
Second proviso may,
They have
I
the
don't
power.
know whether it comes or not. So just kindly direct them if it is
Then the that order is to be set aside
No, but that
main problem. Man.
because
So you also can do one thing.
because the
একটা কথা বলবো এটা
Mr. Rai order, if it is to be set aside, the other side is there. The complainant,
করা যাবে না
without hearing it,
No,
cannot be
that
done.
that cannot be why I'm telling তোমার
If
জন্যই বলছি
the officer will come, I just take the instruction whether it is possible or not. Then tomorrow I'll just give the.
No, I'm doing one thing. So considering this, I'm staying that because in the absence of the other side, I cannot also
Happily spending.
set aside that. Even if you come with the instruction that it can be considered, the order of
But I
demolition has to be
understand,
set aside. That cannot be done without hearing the other side.
Only thing that also
That is the difficulty.
that
I
cannot
don't know
also be done.
what type of construction, I don't know. If it comes within this Badbu,
Mr. Rai, there are two things. Pursuant to this, on facts you have to decide. This court cannot decide. On facts you have to decide whether it can be regularized or not regularized. Mr. Mukherjee says that he has filed an application for regularization. So
that is sorry, madam, that is not correct. He filed it 30. Sorry, he left rule 31 sub rule 2. That is before you have to do it before construction. He
as
has done
net
that.
plan.
He has done.
No, but after this, so he's entitled
It
to
may
that.
it may help him. I just
It may.
when you also kindly.
No, my lord, even then, my lord, also, my lord, the as the appeal is pending.
My lord, I said that
can't say that.
I will not
Set aside of the order.
not demolition. I undertake.
I'm not undertaking. I think Mr.
Injunction.
Rai, considering this, I'm restraining you. I'm directing you to serve because the complaint has to be served. And if this is so, what remains in the appeal?
That
Yes,
is,
my lord, that is the latest judgment of coordinate bench of your lordship's court.
What?
জাতি সম্পাদত্বকালে করে আমি হেরেছি এইটায়
What?
I lost. I was the complaint there. Now, my lord, her ladyship set aside the entire order, the demolition proceeding because my they are also, my lord, appeal is pending. Both the courts below, my lord, dismiss the injunction. Now, my lord, this revision has been filed. There I said that your lordship has no power to set aside, but her ladyship was of the view that unless I grant the interim order, then it came to knowledge that the corporation can, my lord, regularize. Her ladyship has set aside the entire suit and everything.
Rules is there. So, my lord, I'll see, man, whether it come, my lord.
When it has come into force, Mr. Rai? This proviso?
I'll see, man, this is given. But this in the books. Next page is
27th of July 2023.
Yes, sir.
না এটা তো 4/12/2023 notification.
So now person responsible also has been included here. It was not this concept. Person responsible was the concept of Calcutta Municipal Corporation Act.
Our corporation has
One matter after you lost that day, one matter did a division bench by showing this proviso. So I said, no, I also help my son.
মানে ওর হাজবেন্ডকে দেখলাম সবাইকে
disposed of.
Not motion.
Motion in the monthly list of July.
Yes.
No, regularization, Mr. You will get a, because it's a Thakur God, Mr. Mukherjee. It has to be regularized early.
I mean, no.
July motion point. Yes. Call the next matter.
32.
Passover. Passover next.
33, 34, 35,
35.
35.
35, yes.
Your Honor, 54, I'm requesting for short password.
You are for the
I am for the petition.
34.
34 passed over. It has been passed over. Yes. Yes.
Yes, my lord. The learned second Munsif of Howrah district, he is moving with the shoot without having the jurisdiction, pecuniary jurisdiction.
Why?
Because from the shoot, it was valued only 150 rupees.
Yes.
But the schedule, if we go prima facie, it's appear the property listed in the schedule is at least 3 lakhs at that point of time.
What is the suit for?
Suit for getting golds and the jewelry lying in the Punjab National Bank locker. So if you come to the schedule in page number 21, Joro asset. So it will be cost more than lakhs rupees at that point of time.
Where is your application?
And I filed an application under Bengal, Agra, Assam Civil Court Act and Court Fees Act and Suit Valuation Act.
Where is that?
Page number 26, 27. Yes, annex number P2.
Page
30.
Page 30. Very short application. Section 19 of the Bengal Agra Assam Civil Court Act.
Page
30. 30, annex number P2.
Yes. You have not stated anything.
We stated to fix the valuation.
How? What is according to you is the valuation? You have to state that.
No, the value.
Sir, you have to state that. What is the valuation?
That is I prayed before that.
You have not stated anything.
Jurisdiction of the court is only 30,000.
Sir, please value according to you. How it is valued, under what provision of the act, how this type of suit. You have not said anything. You have kept it for the court. Court has rightly rejected.
No, actually
Rightly rejected.
lengthy hearing also happened over there. But nothing was recorded in that.
Nothing is stated in the application.
No, because they never filed.
You have not stated anything in your application. Under what provision? What is the valuation? You have not stated anything.
No, actually, how can I ascertain that the exact
then there is
valuation?
nothing.
It is a presumptive.
Sorry, if you challenge, you have to state that. You cannot leave it to the court. The Dismissed or not withdrawn. Yes, call the next matter.
36 matter for the petitioner. This is an application praying for expeditious disposal of the matrimonial suit. I'm for
Who are you?
I'm for the petitioner husband, my lord. My lord, presently the suit is pending.
Alimony?
Alimony is pending. Is paying, my lord.
Alimony you are paying?
Yes, my lord. And presently it is pending for disposal of application for amendment, my lord.
Which has application for amendment?
My application, my lord.
Your application, you are the plaintiff.
Plaintiff.
This application under Article Constitution of India is দুটোই তো। Yes, call the next matter.
Next matter, my lord.
Next matter also you are appearing. Yes. Yes. Expeditious hearing.
Expeditious hearing, my lord.
Matrimonial suit.
No, my lord. It's an application. It's an application for praying for grant of probate, my lord. It's a contested application, contested proceeding right now.
What is the stage?
The stage is, my lord, today by itself, it was a date in the trial court, my lord, and today, after several adjournments, one of the legatees who is contesting the proceeding, my lord, has filed the WS.
So today the WS has been filed?
Yes, after taking several adjournments, my lord. So
this application under Article
Lordship. I am appearing of the opposite party number 3 petitioner, Lordship.
Yes.
Petitioner preemptor file preemption application under section 8 and 9.
What ground?
On the ground of Kusara as well as adjoining.
Yes, what happened to the miss case?
Lordship, thereafter, Lordship, my client added as a subsequently. My client added as a opposite party in the original proceeding subsequently.
Who are you?
Who are you? My original vendor executed 2 deeds. In one deed in favor of me, another deed in favor of the third person who was the against the preemption was filed. My deed was executed earlier, but not registered, and the impugned deed was executed later, but registered earlier.
But different portions of the same portion.
Same portion. I filed a suit. Suit was decreed. Thereafter,
you filed a suit for what?
Suit for the declaration of my title.
What is the impugned order?
Impugned order, Lordship. I filed a written objection and also with counterclaim. Petitioner filed an objection against that. Thereafter, learned trial court accepted my written objection with counterclaim.
Yes.
Thereafter, petitioner filed an application under 151 praying for modification of that order. That application was rejected.
Yes.
Thereafter, petitioner filed an application under order 8 rules 6C for exclusion of the counterclaim. That is the impugned order. That application was allowed on the hand that by exercising 100 section power under section 152, they modifying the earlier 2 words. That is the impugned order. Lordship, I already relevant portion I showing Lordship. Lordship, impugned order, second page, Lordship. More or less last portion, 4 or 5 line, Lordship. Therefore, Lordship got it. Therefore, invoking the provision of section 152 of CPC, which is found on the maxim actus crucia, that is the act of the court shall prejudice no man. This court think it fit that on his own motion, that order number such and such shall stand amended to the effect that the under section 151 CPC dated such and such is allowed and was initially allowed but without any direction. That application was rejected.
By the order impugned. Matter.
9.
Pass over next.
40.
My lord, I am for the defendant number 1 petitioner led by Mr. Parthapatim Rai.
Led by Mr. Parthapatim Rai. Where is he?
My lord, he is engaged in.
He is engaged. All right. You will move the matter.
My lord, may I start, my lord?
Start. You have to end. Yes, yes.
My lord, I am the defendant number 1, my lord. This is suit for specific performance of contract, my lord. The suit was decreed, my lord, in favor of my lord, the opposite party number 1, my lord.
It is difficult to read the certified copy.
My lord, no typed copy is there, my lord. May I read it?
Yes, what is the impugned order?
My lord, that is order number 83 dated 25th November 2024.
Yes, yes. What has been done by the impugned order?
By impugned order, my lord, I have filed one application, my lord, by
my lord, recording my objection to the maintainability of the execution case, my lord. Suit was decreed in favor of opposite party number 1, my lord, in respect of a specific performance of contract, my lord. And thereafter, my lord, the learned trial judge has held that this objection is not sustainable, my lord, and thereafter allowed to continue with the execution case, my lord. My grounds for objection is this, my lord, that no share, my lord, initially the suit was filed against all the defendants, my lord, and suit was decreed, my lord, against the defendant number 1, 2A, 2B, and 5.
Where is Mr. Rai?
My lord, Mr. Rai,
Pass over.
pass.
Yes, call the next one.
And the petitioners.
Yes.
Suit for partition lordship. I am the dependent petitioner before lordships. In the partition suit lordship, the plaintiff claims 7 decimal land out of 34 lordships.
This is the impugned order.
Lordships, there is in the partition suit, there is order of maintaining status quo, nature and character of the suit property lordship. I obtained permission from the concerned Panchayat authority for, I have already constructed on my 2 decimal land lordship, and up to 10th level lordship I have constructed. Then I filed an application for complete my construction work lordship and given undertaking lordship. In my application I have stated lordship.
This is within your share.
Yes, lordship. Only 2 decimal I am possessing, and from that 2 decimal I have concerned Panchayat authority lordship, and kindly page 21 lordship. I have stated lordship.
No, it has been found that it is above the quantum of your share.
No, lordship, kindly see.
Show me.
Lordship, kindly see
your application. Show me your application.
Lordship, kindly see 21.
Yes. What is your share?
Lordship, in the plain, lordship, kindly see first in the plain lordship. 10 lordships start. It's 11 lordships. They are claiming 7 decimal out of 34 lordships.
No, your share. What is your share?
Lordship, I am 2 decimal lordships.
2 decimals.
Yes, lordship.
And
I am trying to.
Have you stated that it is within 2 decimals?
Yes, lordship. Page 21, lordship. You want to broadcast on it, dash lordship. In the middle portion, Tulu dash star Dokhaliya 2 decimal. বিরাজি নির্মাণের ক্ষতিপূরণ গ্রাম পঞ্চায়েত প্ল্যান অনুমোদন করিবে গ্রাম পঞ্চায়েত গত 28/2/2024 তারিখে
you have your existing building in 4.25 decimals.
I am trying to construct only 2 along with that,
you are in possession of more than that. 4.25.
I am praying for 2 decimals. I obtained the permission from the concerned panchayat 2 decimals.
Here is only 2 decimals. So you have another house on 4.25.
I am filing the application in undertaking if the instruction is
vacation, not before vacation. Come after vacation. Yes. Next. After vacation. Yes, next. 42, yes. Pass. 42, you are appearing.
43.
42, pass over. Yes, next.
Which I was moving on virtually yesterday.
But today I am in a virtual mode.
Your juniors mentioned that it will not be reached today. Mr. Basu. Your junior mentioned because to be taken up tomorrow because it will not be reached today.
Anticipation was wrong. Well, it is a suit for injunction.
This is your other side. Yes,
Tomorrow, so I
have not fixed anything.
No.
They mentioned it. They thought it will be.
They mentioned, but I have not fixed
taken
anything.
up.
Yes.
For injunction.
Kor.
By one lady. Plain case is.
Cannot be done. Suit for injunction.
Plain case is. Her father is the tenant. Her father was the tenant. And her possession is being disturbed.
1 minute. Yes.
Free. Her claim that her father was the tenant and her possession, who is claiming through the tenant, is being disturbed. Allegation.
He is not claiming, my lord, he is a trespasser, his poison, her poison is disturbed. He is not, he is, her claim is through her father, who was the tenant.
Was that in it?
Yes.
That is not the.
So, please. This is a plain case.
Father is living.
Living. 2G will not apply. Then I have a case.
Yes.
On that, my lord, my first submission is this suit is not maintainable. The trial court, when the injunction was moved,
Want the plaint to be rejected.
that, my lord, my justice Bakchi's judgment will show to me. I am not asking for that. What I am praying. If the prima facie suit is not maintainable, can an injunction be passed? Prima facie. Trial judge recorded that and refused the interim order on the ground that is suit presumably not maintainable. The lower appellate court passed an order of injunction considering the electric bills which are in the name of the tenant,
Father.
and consumption is very low. That I am not concerned. The claim are on the basis of the tenant's right. Paka chalaচ্ছে. Tenant. Lower appellate court said, no, these are technical points.
So Basu, all your juniors have not got space to sit.
All are, somebody is there, somebody is probably abroad. Abroad.
I am online, my lord.
He's online.
Is there. Now, my lord, kindly come to the plaint, page 26.
26, yes.
26. But kindly come to the prayer first, then I will come to your lordship. A decree for permanent injunction, page 32. Restraining the defendants under their main servant and agents from dispossessing the plaintiff without due process of law from the suit property.
Yes.
Take the case of a trespasser. No right at all, licensee, I could have understood this prayer. But when her claim is on the basis
So
of
what is her claim?
Claim.
What right they are claiming, or she is claiming?
Aberment is my father is the tenant. Is the tenant. His case is the tenant. If father is the tenant, I am assuming for the time being, according to us, he was the tenant. Assuming, my lord, he is the tenant. Can a suit be maintained by tenants in heirs when he is alive? Can you see the aberments?
So this is the ultimate relief, which is
This is
claimed.
ultimate injunction.
Yes, and in aid of
Nothing
this,
for.
in aid of this temporary injunction application,
Sought for not to disturb her. Now, kindly come to the order.
yes, we are trying to show the plaint, some averment.
Yes.
Where?
Kindly see that. Kindly come to page 27.
Yes.
Paragraph 2.
Yes.
Kindly come to first page, middle. The plaintiff is the daughter of one Siddhartha Bhudoria, who is the tenant.
Where?
Middle. Six
First
lines.
paragraph,
First
middle.
paragraph. 5 lines from the bottom. First paragraph.
Yes, is the daughter of one. Yes.
Is the daughter of one Siddhartha Bhudoria, who is the tenant. I am assuming this is correct. Is respect of the suit property at a monthly rent of about 2,500. Then, my lord, paragraph 2. Originally, the said Siddhartha Bhudoria was inducted with the property as a tenant by Rabindranath Tagore, Rasendranath Tagore. 3. The said Siddhartha Bhudoria used to deposit rent to the said such and such. Then, my lord, kindly come to paragraph 5. The plaintiff said that the said Siddhartha Bhudoria has all along been a monthly tenant as in continuous occupation of the suit premises.
Sure.
And 7, the plaintiff said that recently the plaintiff's father was suffering from severe. ছয়টা পড়বো? নিশ্চয়ই স্যার। পরের লাইন. The same was dwelling along with his family, including the plaintiff and Sangeeta Dudoria, and has been paying rent along with electricity and security charges. Copy of the last few electricity bills issued by the CSC, standing in the name of the father of the plaintiff, are annexed herewith and collectively marked. Then, my lord, kindly come to 7.
Paying rent and electricity.
ঠিক আছে।
লাগাচ্ছে electricity.
ঠিক আছে। The plaintiff said that the plaintiff's father and mother, being Siddhartha Dudoria and Sangeeta Dudoria, are senior citizens and are suffering from various health ailments. 7. The plaintiff says that recently the plaintiff's father was suffering from severe discomfort in his spine and as a result had to undergo a major surgery on or about July 2024. Since then, his movement has been restricted. Then 8. The plaintiff states that the plaintiff is a working woman and due to her job commitments, she has to remain out of the home for a considerable period of the day and taking advantage of the same and the illness of Mr. Siddharth Dudoria, the plaintiff defendant number 2, through the defendant number 1 and other miscreants claiming to be owner of the suit property are constantly attempting to disturb the peaceful possession of the plaintiff. Then, my lord, can I read that? You will also will not find anything. His independent status. Independent status, my lord, will not find.
All right. So they will show their case.
Let them. I am relying on the plain case. I am not disputing their claim. They are claiming her father is the tenant.
Not also because at the identity
stage. Father is the tenant and she is filing the suit. Now kindly come to the trial courts how it has been refused.
Yes.
Page 45. Hello.
Page.
Kindly come to page 85.
85 or 45?
45. Now, my lord, kindly come to order dated 8th May 2025. Third line. At this stage, learned advocate for the plaintiff submits that the petitioner plaintiff is the daughter of Siddhartha Dudoria, who is the tenant in respect of the suit property at the monthly rate of such and such. The petitioner, on occupying the suit property and staying in a joint mess along with her father and mother, the said Siddhartha Dudoria was inducted as a tenant by one Rosindranath Tagore, the original owner of the suit property, and by dint of tenancy agreement, and the father of the petitioner used to pay rent to the said original owner and he used to issue rent receipt, but the said original owner died in the year 2013, leaving behind a will remaining wherein he appointed Mr. Srilekha Tagore as it not necessary. Can you come to the bottom, little bottom? The said Siddhartha Dudoria is a monthly tenant and is in continuous occupation of the suit premises and is enjoying the same along with his wife and the petitioner.
The petitioner submits both her parents are suffering.
ঠিক আছে, থাক, ওসব দরকার নেই। Now kindly come to the bottom. Heard and consider. After perusal of injunction application and documents filed the plaintiff, it appears to me that though the plaintiff claimed that his father's, namely Siddhartha Dudoria, is a tenant in respect of suit property, but it is quite astonishing to note that the said original tenant of suit property has not filed the present suit, claiming himself to be the tenant of the suit property. Furthermore, it is quite irritating that though the plaintiff petitioner claims sorry. Though the plaintiff petitioner claims that his father is suffering from severe discomfort in his spine and has undergone major surgery in the year 2024, and since then his movement has been restricted. But apart from this, the discharge certificate of July 2024, the petitioner had not filed any recent documents relating to his death. Moreover, the father of the petitioner is neither made party in the suit, nor the petitioner has claimed any document to show that his father has authorized her to file this suit. So, according to the trial judge, the suit is not maintainable because you cannot spouse others' cause. I will cite a judgment of the division bench of your lordship's court. On this, my lord, they are insisting I am not on trying to go on mainly facts. Kindly come to once page 85. Page 85.
Discharge summary.
Discharge summary. Can you see the address?
Yes.
Siddharth Dudoria.
Siddharth Dudoria is the father.
He is the tenant.
Yes.
And his address is
Mayfair Road.
Yes, yes.
Mayfair Road.
So, my lord, this is not the suit premises. What
Yes.
my next, on fact, I don't want to disturb you, lordship.
Sir Basu, one may have two premises.
That's why I don't want to cite this is insisting over my learned friends. I have shown to lordship. Why? According to our case, he has surrendered his tenancy, staying somewhere else. This is our case that I will place, my lord, in when I will file objection. So, my lord, the trial judge refuse the injunction order on the ground.
So according to you, you are in possession.
I am in possession. And there is a suit filed by me, injunction granted. That even that I am not going. I want to stick to.
Cannot at this stage.
I want. এত বড় argument করলাম। I want to stick my case that
Not be for you, maybe for Mr. Chakraborty's interference.
That if the suit is not maintainable, if we can satisfy my lord, then whether injunction in any form can be granted. Now, what is the answer to this? Appellate court what said? Kindly come to the order impugned.
Which volume?
My lord,
Which volume?
all this is with leave has been filed. Don't find certified copy. 112A.
Oh,
Second
certified
one.
copy is not there.
Not there.
Because this is with leave.
Leave.
112.
112A.
Yes.
My lord, I will not travel over the entirety. Kindly come to 112C. ঠিক আছে তো?
Because those are the facts.
Those facts reiteration. Kindly come to fact remains. It starts with fact remains.
Yes.
Fact remains that the father of the appellant plaintiff is the tenant and the instant appeal has been filed by the daughter. Assigning the ground as stated in the factual backdrop as stated above has prayed for injunction apprehending disposition and from hindrances to and from the free ingress and egress of the suit property. From the document it also appears that the father of the appellant, the original tenant, was diagnosed with ankylosing with their column fracture had to undergo such and such and future such and such. Therefore, then my lord, this is the conclusion. Therefore, prima facie it cannot be overlooked that the settled possession in respect of the suit property is in favor of the appellant. Out of blue. Her family and is also settled even a trespasser in the property. His not case is a trespasser. His case is she is the daughter of tenant. Had it been a case of trespasser, I could have understood this finding. That independently claimed that I have inducted by somehow, I am there in the possession, so don't disturb me. But his right is emanating from the father's tenancy. Whether a person who is residing with the tenant prior to his death can get the benefit of 2G. I am asking the question to myself. Then, my lord, the appellant plaintiff is the daughter of the original tenant and apprehending disposition sought an order of protection concerning the suit property and to substantiate their claim of possession into the suit property. She has also submitted certain documents which prima facie established her possession into the suit property. What are the documents? Electricity bill. But these documents is required to be looked into admitted document. But kindly come to page 63.
Page
63. Agreement দরকার নেই গ্যাস কানেকশনটা দেখা so kindly come to 69. This is rent receipt of whatever in the name of Siddhartha Dudoria. Has Malashkali got it? Then my lord, I gas কানেকশনটা কোথায় গেল এইটাই চাইছি but kindly come to 79. গ্যাসটাই আসল 79. So kindly come to 79. These are the documents prompted the learned trial to hold he is in settled possession. This gas connection is in the name of Siddhartha Dudoria. And then prior to that, man will get the electricity bill. Just free page 78. তুই কেন ওদের আমাকে ডিস্টার্ব করবি আমি যাবোই না
Where this gas cylinder is going?
Where is it going? It is in the name of the tenant.
Where it is going?
That I don't.
Don't open your mouth too wide.
I know that.
It's there in the document I have seen.
Yes.
That is why I'm asking you where it is going.
This document can establish the possession of the plaintiff. Here, my lord, is the concern with the possession of the plaintiff. Whose name it is? The name of Siddharth Dudoria. Electricity bill, free page. Kindly come to the previous page. Siddharth Dudoria. Have you seen that?
Yes.
Have you seen that? And the consumption also, you can see the consumption. 510. 11th February 2025.
510 means?
Is the consumption. Rupees 510.
No,
It is actually 3 or 4 units. It is actually 3 or 4 units.
78.
Lordship will kindly take, my lord, with the leave of Mr. Basu, it is only 3 or 4 units per month this year, if and when compared to the earlier years. This year it is 3 or 4 units.
No, this 510 is the bill.
Total amount.
Amount is 510, but my lord, the units your lordship will find on the obverse side, it is 3 or 4 units, subject to correction.
Where do you get that, Mr. Mojumdar?
My lordship will find that your 6 months consumption, your lordship will kindly take the page.
Yes, 6 months consumption I've got.
Yes, your lordship will find it is 3, 2, 1. This is like that unit.
It is 510 for 2 or 3 months.
CSC month.
I am not, even I am not on that.
Yes, yes.
Lordship has got that, my lord, 3 or 4 units per month.
Oh, 75 can my lord get. What my lord is asking for, kindly come to 75. 75.
Yes.
Can you see the consumption? Previous reading and present reading, same. This
Yes.
is my lord, meter rent, these.
Yes.
However, my lord, whatever consumption is there, it is consumption in the name of the tenant. And the suit filed by a person who claimed to be residing with the tenant, not independently. So in that event, my lord, to maintain this suit, had it been a claim, I am a trespasser, I am residing there, I could have understood. But her own entire claim based on her father's tenancy. In that suit, my lord, this order was passed. Fact remains, I have also filed a suit. In that suit, there is an order.
But you cannot produce those documents.
Record of the court. That's why I am showing.
But
No
I
fact.
didn't.
The order is at page 328.
Showing an order of the court.
But Mr. Basu, can you
But can I not
rely upon that?
Can I cite a judgment for your lordship's consideration? Which I will do. On that context, I will look into it. I am not saying that whatever my claim, whatever claim is genuine, not
Page
328.
328 at 330. Second volume, my lord, second volume.
Second volume. But this is prior in the point of time.
This suit, my lord, kindly give me 1 minute, 30 seconds. This suit was filed by me against the father and the son.
Son is also there.
Yes.
Now it's the daughter coming up.
Yes. Getting this injunction against them, kindly come to the. After filing this, well, now the daughter is coming. They enter appearance in this proceeding and prayed for time for filing written objection. The tenant appeared, the original tenant.
Yes.
Clear to my lord. This suit was filed by my client to restrain them from disturbing after the possession is handed over. There, the tenant and the son is party. The injunction was not granted. This is the order. Our suit is fixed tomorrow, my lord, for injunction.
So no injunction has been passed.
Tomorrow is the date fixed. They ask for objection. The father, tenant, enter appearance in that suit. Tenant enter appearance in the suit and prayed for time for filing written objection. This is the scenario. This is nothing to be disputed. That's why I placed before my lord. Now, my lord, whether the lower appellate court was correct in, my lord, reversing a finding without any reasoning thereof. Trial judge is of the view that daughter cannot independently file a suit because he has no nexus with the tenancy. It is not a case that father died, so 2G will apply.
Tenant has not come, tenant has not authorized.
Not authorized.
That is the finding of
entire
trial.
case. My lord, this is the ground, my lord, we have challenging that, because another thing, my lord, after this order is passed, which your lordships can be appreciated, this is a matter of record, the final application for police help. Meaning thereby, they are not in possession. They apply for police help, and by this process, they want to enter into the possession. Whether this is this Calcutta's way to get the possession which has been handed over by the tenant in favor of the landlord. Well, I cite two judgments for your lordship's consideration.
Yes. For what proposition?
That
The Basu, don't look at the back, please look at the front. Yes. And keep your right ears closed. The juniors are on your left.
This is reported in 2009 to Calcutta High Court Notes 379. It is off-courted judgment. My lord is fully aware of these judgments.
Calcutta Swimming Club.
Yes.
Yes.
Why? From 2009 to Calcutta High Court Note 379. Paragraph
13 onwards.
Kindly come to paragraph 13. In order to maintain a suit, the plaintiff must prove that right to sue has accrued in his favor. In our judgment, there is no right to sue until there is an accrual of right asserted in the suit and this infringement, or at least a clear and unequivocal threat to infringe the right of the defendant against whom the suit is instituted. A plaintiff cannot file suit alleging that by the action of the defendant, although none of his right is infringed, yet somebody else's right is going to be affected, and such right of the third party should be protected. We therefore privacy do not find any cause of action for the plaintiff to file a suit.
Yes. Yes.
So, my lord, here admitted case is even not pleaded. I am not going my submission. Even not pleaded that he has an independent right. All claim are through her father. Whether, my lord, applying this judgment, the suit can be said to be maintainable, and there is a privacy case. Then the question of granting injunction will come. And what is the finding so far as the injunction? That
some documents has been produced.
What are the documents? In the name of the plaintiff.
To show their occupation.
Kindly don't use, sorry, my lord, I should not say, now my lord not advocate. My lord, don't use the word their possession. No, her possession. This is the distinction.
Yes, her possession. Occupation.
Her occupation. Where from my lord is getting her occupation? From the documents showed before the court.
Anything more, Mr. Basu?
My lord, your lordship knows that judgment of those, when a trial court, on the basis of factual basis, finding a strong case made out for refusing, the appeal court will be slow. Here, my lord, trial court given a positive reason. 2006, 3 Supreme Court cases.
Other page, sir?
312. Hey, at the end of two? At the end of This is also off-courted judgment. Kishore Koitan.
Yes, paragraph.
Paragraph 5 to 7, my lord has earned a substantial amount not by showing this judgment when this side of my lord was here.
Yes.
5-7. There, my lord, the court on a strong case made out by the plaintiff refused. whether the appellate court on the self-same facts can alter its finding without any reason. Five থেকে দেখ 5, 7, 5 আর 7, 5 আর 7.
Yes.
This is well established principle. I am not multiplying any judgment. These are the 2 points I am having. That no possession of the plaintiff was shown to the court, even if there is a prima facie case.
So according to you, the plaintiff
not
could not establish any show his prima facie legal right.
Of her any right.
Legal right.
Legal right. Not even pleaded, showing he all our case is that father is the tenant. When the father is alive, I am not making any case of mine before my lord, because at this stage I cannot.
Anything more?
My lord, I did not show too much. Order on rule 8 language. Order on rule 1.
Order on rule 1. Yes.
বলার কি যেটা বলতে হবে স্যার। Any right
Yes.
Any right to relief in respect of or arising out of the same act or transaction or series of acts of transaction alleged to exist, such person whether jointly, separately or in alternative, and such person brought separate suit in itself. So my lord, his right has to be infringed. What are her right? I repeat, my lord, pardon for repeating. Had it been a case of trespasser, the lady was somehow inducted there, say that I am in possession of the suit property, so don't disturb me. All along plain case, if you go to the plain case without any demo on our side, you also will find she is espousing the case of the tenant. So that is permissible.
Yes, Mr. Chaudhary.
Kindly have a look at the plain.
Yes.
কি আছে করে নাও
এই জন্য না এই ছটা বন্ধ কোর্ট বসতে
কি
আজকে কেন
Yes.
আজ করবো না
Yes, yes, Mr. Chaudhary. Yes.
কে গেলে বাইরে বেরোলে যখন আমাকে মারবে ধরে তখন বাঁচাবে এসিও বন্ধ হয়ে গেছে
প্যারাগ্রাফ 1 last 3 lines. The plaintiff is occupying the suit property.
What is the legal right claimed by you, Mr. Chaudhary?
The legal right claimed by me is I am the daughter of a tenant, admitted tenant, who is staying in the property and looking after my parents because of some medical issues.
I'm asking you, what is the legal right?
Legal right is I am to right of occupation, and if I have
capacity
as a licensee of my parents, and I am as the daughter, I am taking care in their old age, and because my father has suffered a medical process, an injury in the spine, a surgery in the spine, for which, my lord, his mobility has been affected. I am enforcing this right, and this is simpliciter a suit under section 38, and only possession, my lord, that can be possible. That is possible and permissible.
Be really factored in.
There are 2 paragraphs in the plaint I show your lordship. Kindly see the Kindly see the last 3 lines. Plaintiff is occupying the suit property joint mess along with Siddharth Dudoria and her mother. And para 2 onwards, my lord, who is the original tenant, and my lord, the tenancy related issues have been prepared. Kindly come to para 5.
Yes.
Plaintiff states Siddharth Dudoria has all along been a monthly.
These are all with regard to who is the tenant.
Correct. No, one line is there, madam. Para 6. Plaintiff states plaintiff's father and mother, being Siddharth and Sangeeta Dudoria, are senior citizens suffering from various health ailments. Therefore, in order to take care of her ailing parents, the plaintiff has all along been in occupation of the suit property, which shall be evident from the plaintiff's document. Voter ID card, driving license, everything has been given.
Yes.
My lord, voter ID card is at page 83. Page 83, Lordship will have a look. Driving license at page 84.
Are those documents to prove occupation?
No, to prove possession. I possessory right, to prove possessory right.
Those documents?
Yes.
Voter identity card?
Yes. Well, two things are there. Well, today, as a proposition of law, if a tenancy is admitted in favor of the parents, and if the children, let us assume, my lord, the ingress and egress of only the children are affected by the landlord. Can, my lord, a section 38 suit lie or not lie? All I have to show is that I am in possession. And I am there in the house. I have asserted my right specifically on the averment that my parents are the tenants. I have a right of possession in that because I am taking care of my
as daughter of the tenant.
And even, my lord, in terms of the Premises Tenancy Act, Lordship knows 2G, my lord, after death, what happens, well, that's a different issue. That is different issue. Had it been, my lord, my learned friend, I join issue, my lord, I heard the submission. Had it been any declaratory right had been sought for, there would be problem. But, my lord, it's a simpliciter section 38 suit. Kindly bear in mind. Other than mandatory injunction, nothing has been asked. My lord, one judgment, Lordship will just consider. 2018-12 SCC 647.
আবার রিলিজ কি 4:30 বেজে যাবে রিলিজ কি করে
2018
একটু বলে দিন না বলতে হবে চলে যাবে চলুক না চলুক তোদের টাইম চলে গেছে
Kindly see paragraph 6 to 8.
পারবার না রে কি বলতে হবে করতে পাওয়া যায় বল
Paragraph 6 to 8.
কি করে যাবো বসে জল জল কি রে জল বসে বসে চাকরি করে বলা এ ওই খালি
Para 7, my lord, placitum A. We refrain from going into the merits of the contention for two reasons. Firstly, since the present suit and further appeal thereon emanates from suit pertaining to permanent injunction, where the touchstone which the suit has to be decided is lawful possession and not ownership. Secondly, the appellant defendants have filed separate suit in so and so against Madhavan Pillai and the respondent for a declaration that appellants are owner. Secondly, I am not. So, my lord, my short question, two questions are framed. Is my possession as a daughter of a bona fide tenant unlawful? If it is not, I am in lawful possession. There is averment in the plaint. They are all senior citizens. I am taking care of them. Their mobility is affected. I have filed the suit because my ingress and egress, even for other medical emergencies, also is being affected. Paragraph 8 of the plaint, Lordship will see. I read it out. Plaintiff is a working woman and due to a job commitment, she has to remain out of home for a considerable period of the day, and taking advantage of the same and the illness of Siddharth Dudoria, the defendant 2 through defendant 1 and other miscreants claiming to be the owners are constantly attempting to disturb the peaceful possession of the plaintiff and plaintiff's father. However, till days, neither the previous landlord nor the defendants who are claiming to be the new owners have issued any letter of atonement. So, my lord, my case.
Where is the question of issuance of letter of atonement to you?
Not to me, my father. My father.
So you are canvassing the right of your father or your right?
Where is the bar?
I'm asking you.
Yes.
Are you canvassing the right of your
No,
father
I am
or your own right?
I am canvassing my own right as well as the right of my father. For the simple reason, my father is not in a position to come physically before this court because of the ailment and surgery. A surgery today, my lord, if what is falling from your lordship, if this is looked upon strictly, my lord, if my father is the tenant and he is immobile for any reason, Let anybody will come and occupy the property, put a padlock over there, and will not be, the law will not demand that the plaintiff has to come himself, not even in a position to execute a power of attorney. And I have said it on my own that I have come canvassing the right because my father, I am looking after, I have a possessory right. My right is as a licensee of a bona fide tenant. I am looking after my father. So, Ballot, can I be obstructed? But I, with respect, my lord, I don't find any problem with this proposition. But what is troubling your lordship, had a declaratory right been sought for, where I am seeking a declaration as against the landlord in my favor, there, my lordship is perfectly right. The principles that is troubling your lordship, or what has been canvassed by my learned friend, my lord, that will have some bearing. There is also a question of the suit being barred. But a mere section 38 suit, where, my lord, all I have to show is my possession is lawful. My lord, will perhaps kindly see section 38 once.
Other matters.
Kindly see section 38 once.
Other matters release.
এই বলে দিন that accepting this matter, other matters release.
Release for today.
Yes. Yes, Mr. Chaudhary.
In a 38(2), one is, kindly see subsection 2 is arising from a contract, that's different. Then 3 is when defendant invades or threatened to invade.
Section 1.
Yes, subject to the other provisions contained or referred to in this chapter, perpetual injunction may be granted to the plaintiff to prevent the breach of an obligation existing in his favor, whether expressly or by implication.
Where is the obligation?
Well, the obligation is,
obligation has to be between the parties. Obligation has to be between the parties. Show me from your plaint what is the obligation pleaded.
But obligation has to be between the parties in a contract.
No. Contract is subsection 2, Mr. Chaudhary. That is why I asked you to.
So, my lord,
it's contract. It's not contract.
My lord, let us test the proposition. So, my lord, in case, my lord, what is falling from your lordship, in a tenancy, the father.
I have not said anything. I want to fit this case under a particular provision of a statute.
My lord,
so whether it fits under section 38.
Yes, my lord, the obligation is, my lord, as between the plaintiff and the defendant. Once I satisfy that, my lord, I am the daughter of my father who is a tenant, and I am entitled to.
Mr. Chaudhary, obligation has to be between the parties.
Well, let us test it.
Yes.
There is a tenant in any premises. Well, the landlord comes and puts a darwan who refuses any visitor, who refuses anybody else to enter the premises.
Very good.
Well, the son comes back to his home, he is refused. Well, can the son file a suit?
I'm asking you under what provision?
Under section 38.
Subsection 1.
38(1).
What is the obligation? Please.
Well, the
obligation between these parties, because one is trying to enforce an obligation against other party.
Yes.
So, what is the obligation between these? What is the obligation?
The obligation is flowing to me through my father, which I am entitled to enforce. Because of the medical emergency, the situation which I have pleaded in my. This is first. Number 2, even independent of that, well, if there are other occupants in the premises, let us say, my lord, the parents, other relatives who are close family members who have come, obstructed in the same manner. For some reason or the other, the original tenants are not in the suit property. Can they not file a suit? I can understand, well, they can have a chance if they say I am rank outsiders, no nexus over here, I am trying to occupy. That is a different issue.
No. I feel that you are not a rank outsider. You are a family member. We can take it at that.
Correct.
You are a family member or close family member of the original tenant. Only thing is, what is the obligation between the landlord or an owner of the property and a family
My lord,
member?
one of the incidents of ownership or my lord, transfer of property, my lord, which goes with that I have the right, and when I am transferring that right title interest, whatever capacity, tenancy or lessee whatsoever, that I grant that lessee the right to enjoy the property in a lawful manner, which
lessee, Mr. Chaudhary, this is as per the contract, that is as per 2. So it's the lessee. So it's the obligation between the lessor and the lessee. One is other obligations apart from the contract. That is why I'm asking you, what is the obligation? Please connect the obligation between the parties to the suit, because it has to be connected. Because one is claiming relief against the other by virtue of some obligation.
yes, the obligation is to be in the property where I am, which is in my possession, and I have been staying there. Today, 10 days, 10 months, 10 years, I am staying in the property, no problem. Overnight, I come when my father is indisposed because of his old age, he is not in a position to come. They lock the door. They lock the door, they don't let me enter. I can't come to court. The obligation, what is falling, if Lordship interprets it's only can be the parent, my lord, it will create havoc. That cannot be the law.
Asking you what is meant by this
obligation. The obligation is obligation in law, in contract, whichever way Lordship looks at it, that if, my lord, the tenancy is correct, my lord, any bona fide licensee of the tenant who has a right to enter the property can, my lord, the landlord prevent any rank outsider to visit me?
So, according to you, in a lease, let us assume, any family member of a lessee can approach the court alleging breach of terms and conditions.
If his possession is affected, if he can show he is in possession and his possessory right is being affected to the extent of injunction, yes.
Possession is being given by virtue of the lease to whom?
By to the lessee. If the lessee can't come, then also they can't come. That with respect, my lord, that can't be the law. That can't be the law. Obligation, because that is why, my lord, I cited the judgment. Section 38 talks only of possession only because of this reason. Because only possession here is material. Even, my lord, courts have gone to the extent of a trespasser. If he is in possession, he is entitled to protect his possession by way of injunction. We have these, my lord, declaratory suits.
Show me both the contrary views. There are two views.
Very well, my lord. I shall show you a lot.
There are two views on this. Whether a trespasser can obtain an order of injunction against a rightful, against a rightful owner.
Correct.
It's equally settled that even a trespasser cannot be evicted without due process of law.
Correct.
And it's equally settled that a trespasser
now, my lord, as a corollary
against a rightful owner.
My lord, if what fell from your lordship, let us test that. Well settled, trespasser cannot be evicted without due process of law. Now, a trespasser, my lord, if he is shut outside the property and he comes to seek injunction and is not there, in effect, it's eviction. My client is suffering eviction.
She is not pressing it. Can you see
My
that?
client is suffering eviction.
That's why I'm asking you. So, where are the
Pleading
decisions?
is not that.
My client is suffering eviction. If I am shut out of the property and on this ground they come and put a padlock and then they say that only the tenant should come, knowing fully well because of his medical condition he can't come. It's him.
Appearing in the suit.
And because of their old age and all, they are not in a position. He suffered a surgery, spines.
And Mr. Chaudhary also, while granting injunction, court can direct a party to give a bond. In case the suit is dismissed, he will compensate.
For what?
For the losses, damage suffered by the other side for this order of injunction. There are judgments on this also.
Yes, that is well, that's in a different context. I understand what is that.
Also,
That is in a different
direction to
context.
pay occupation charges During pendency of the suit.
Yes, they are ranked trespassers.
Yes, yes.
Correct. So here, my lord, we are not involved. We are not considering these principles at all. It is not a case that
Since you said that trespassers cannot be evicted, that is why I am.
The case made out.
so that is what I am saying, that trespassers cannot be evicted, due process of law, compensation after due process of law, my lord, mean profit is also there, whether you are trespasser and all that. And even
That is
even
one
deholds mean profit. I understand what is falling from your lordship.
It's one thing, one line of judgments are there, even during the pendency of the suit, if the court wants.
Correct,
can ask
correct.
Either occupation charges or bond even. You may not be required to pay something now, but you have to give a bond to agreeing that you will compensate if
The KK Saha and all those line of judgments.
2001 Calcutta.
Yes, that is all right.
know all
That is different. That is different, Milord. I am not on that. But we are here on a very basic premise. Whether a daughter of a tenant can file a suit to protect the possession. This is the short question in law. Plaint is very categoric. The right is being enforced as a daughter who is taking care of the ailing parents.
So your sum and substance, your point is that you are in occupation of the premises as a daughter of the original tenant.
Along with my parents.
Yes, along with your parents.
Yes.
And you are canvassing your right as an occupant of that premises.
Yes, because I am being prevented ingress and egress, so it is so acute that now I have to shift my parents from there.
That is that obligation and infringement. For infringement of that obligation, you have approached the court and have
and as at the ad interim stage, as a prima facie case, a prima facie document, I have given all this. The electricity bills are
the gas supply bill. The electricity.
But the fact that I am residing over there, my voter ID is.
Where is the gas supply bill, Mr. Basu?
Page 79.
Where is the location where equipment is there?
My lord?
Where is the location where the gas is being supplied?
14A Guru Shodha Road?
No. Subject to correction.
That
That is the address of the consumer.
Supplied
But supply location is elsewhere.
No. Supply টা কোথায় হচ্ছে না? Confirmation করো না? Well, I confirm this.
From this document itself, it's apparent.
But then I am missing something which lordship is seeing.
See the landmark. Area equipment. This is the area where it is being supplied. Equipment is lying there. Not in Guru Shodha Road. It's in Ironside Road.
Yes. No, my lord, something is wrong, my lord. I don't
Yes.
think that is.
You have not got that.
Yes,
Yes.
lordship is looking at iron.
Landmark.
My lord,
Category.
that is a broader area. My lord, I shall.
Landmark is blank.
Lordship just keeps it tomorrow. I will confirm.
Landmark is blank. Category is domestic. Please see this. And area equipment is Ironside.
Yes.
Then quantity is 4.2.
14.2.
Yes, 14.2. So this area is, you must be aware of that. The suit premises is Guru Shodha Road and Ironside.
My lord,
Road is in a different.
my lord, I'll get a clarification also tomorrow. I don't think, my lord.
Ironside Road is in a different.
No, I know lordship will know Ironside Road better. I'll get a clarification. My lord, this is
the area equipment.
This is the larger. My lord, this is the Ironside area which caters also to Guru Shodha Road, which is on the other side. I will get it clarified.
Very difficult at times to shift the address and other things nowadays.
No, my lord,
So,
this has been, my lord, I shall get a clarification and I shall come back. But this is on fact, let us assume. I'll get it clarified. Gas will not be a problem.
Gas is the problem.
Mr. Basu says otherwise. That is the problem.
No, that is not the problem. Well, why will I? Well, kindly visualize. Why will I shift? But well, these are all questions which will come up in affidavit. Let us.
Prima facie, Mr. Chaudhary. Prima facie.
Said nothing.
Nothing. On the documents.
Very well. I
have
will get
relied
that
upon.
clarified.
Which you have relied upon. Though
I'll
Mr.
get it
Basu has,
clarified.
I'm telling you, Mr. Basu has not raised this point.
I told
He has said,
I told my friends, it has not come. But I have only one premise.
relied upon
I
that.
have only one premises, so I cannot supply others. So those who have different premises have the
I have no premises at present.
Let us,
I have no premises at present.
let us,
I have no premises at present.
very well, I'll come back tomorrow. I'll clarify this.
Only that clarification, I'm concluding the hearing.
Very well.
Give that clarification.
I'll give that. हमारे just clarification तो भाई ये कैसे रही है time?
All right. So you want tomorrow how much time? 5 minutes?
5 minutes.
To be mentioned tomorrow?
consent with consent. Benefit on the both side, both gas will get.
2
p.m. Can it be at 2 p.m.? Lordship has 5 minutes.
2 p.m. there is a larger bench.
Oh, I see. Very well, my lord.
But larger bench will not continue for much time. No, I do not know because some matters has been mentioned today morning citing urgency. So I have not yet decided at what time I will take. Since you have said you have difficulty in the morning.
There may be, my lord, because tomorrow is practically the last day.
That is why. I'm keeping it under the heading to be mentioned. If not possible,
Very well, very well.
If not possible,
If it is not possible, he will inform me. I will come and disturb you, Lordship, jointly.
Mr. Basu Lanet.
Dictation in progress, no?
Please conclude. Otherwise, tomorrow.
Requires. Only thing I will show to Lordship what he has said. I am not telling now. He said he is claiming through
Your points or the judgment, if you want, you can complete with regard to that clarification. Mr. Chaudhary will only give that clarification.
Submission is he is the licensee of the tenant.
Yes.
Can you keep in mind? Nothing else. Can you keep it in mind?
And he says he's an occupant of that premises along with the tenant.
He is the licensee. This is the specific term used. He is the licensee of
Licensee is a legal term which he has issued.
He's used that.
Which has used licensee.
Licensee of his father.
Yes.
This
Licensee of his father, because that is the legal term.
Nothing else.
And he has said on facts that he's in occupation along with the tenant as member of the family. That is the.
That is, I have nothing to controvert because factually I will not controvert. I will rely on his.
The judgment which he has relied upon.
His judgment is title also dispute. If you lost it, I have not hurriedly could not get it. When my lord is giving time tomorrow, I will, if necessary, I will say. Otherwise not. If necessary, otherwise not.
Because tomorrow is the last day.
Yeah, I know that.
That is why.
I know that, my lord. I will do justice to my lord.
Your junior mentioned that if not today, tomorrow.
Wrong assessment of justice, Bhattacharya. That's why.
Mr. Basu Lanet, senior advocate, appearing for the petitioner, concludes his argument. Mr. Chaudhary Lanet, senior advocate, concludes his reply argument. However, Mr. Chaudhary Lanet, senior advocate, prays that this matter be fixed tomorrow for some clarifications. First up,
of a document, my lord, you can indicate the document also.
From
And one custody matter morning, Lord. Tomorrow I have to hand over the child. If
tomorrow it will be taken up.
Yes, tomorrow it will be taken up, Lord. I'll mention again in the
item number. What item?
It's not today we have filed with your lordship's leave, Lord. Tomorrow I shall mention again, but I am giving you lordship's officer the number. Otherwise, Lord, it will become infructuous.
In the presentation form, you have mentioned tomorrow's date.
Yes, yes, my lord has granted leave. I mean, number
Who is any caveat, Mr. Chokko?
Caveat served. Served. Caveat served.
Please inform. Otherwise, it's difficult.
No, no.
Custody matter, in
Yes,
their
yes,
absence,
Yes, it could.
or I will have to appoint Mr. Basu as the amicus.
Lord, then we are right now pass the order.
Administrative amongst us. I don't find so. Is there no?
Amicus,
Amicus to settle.
amicus,
তবু ঠিক আছে।
amicus, to resolve that dispute between the
হ্যাঁ তাহলে তো হয়েই যাবে
parents.
শেষ।
যা কাণ্ড বাবা
Thank you.
দেখে দিয়ে দে